Yeah. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 14th. We have 9 bills on the docket, and we're going to start off with Senator Muse with Senate Bill 606. We'll then go to Senate Bill 755, 763, 764, 850, 568, 752, 754, 744, and then we'll end up with Senator Folden, Senate Bill 745. You're not last because we don't love you. It's okay. Okay. All right. So then we'll start off with Senator Muse, Senate Bill 606. Welcome.
Thank you very much, Mr. Chair, members of the committee. I'm going to invite my panel to come up with me. We have the Honorable Aisha Braveboy. She is our state's attorney in Prince George's County and Deputy State's Attorney Perry Paula, and also representing the Prince George's State's Attorney's Office. I'll give a brief overview, then I'll turn it over to them, and for any questions that you have of us, I think they'll clarify most of it. They will provide the testimony regarding the impact that these crimes have. So Senate Bill 606 as amended would change the organized crime statute by adding civil forfeiture language, civil remedies, and it increases the penalty and the changes, and it changes the definition of street crews, which they'll explain. Senate Bill 606 as amended is intended to address the pattern of organized crime activity in our neighborhoods. If I were to put it this way, it's going after the big fish now and not just those who we see in the streets. Nowadays, groups of individuals may not necessarily be a gang or a street crew, but they're groups of individuals who have a pattern of organized crime. And so SB 606 would allow civil remedies under the criminal law article for crimes related to fraud, robbery, impersonating an officer, obstruction of justice, perjury, threat of mass violence, insurance of fraud, and on and on. A number of them, as you see in the testimony that's in your packet. This bill then, if found guilty of any of the violations, it will be a felony conviction with no less than 5 years and up to 20 years, or a fine not exceeding $25,000. In closing, I am a strong advocate for expungement and giving people a second chance when they make a mistake. However, I do not support or endorse organized crime, and they will put 2 statutes together to come up with this bill and explain how we will get this done in Prince George's County and throughout the state. There's been specifically a notable increases in number of crimes involving carjacking, theft, drug distribution, and it's not just those who are committing it, it's those who are way up the chain, who are financing it, racketeering, on and on, those who are benefiting from these crimes that we will never see, but there's a way that we can go after them now and try and shut some of this down too. I'll stop and turn it over to our esteemed state's attorney and others who can tell you how we're going to get this done. Thank you. I hope that as you listen, you'll agree and we can have a favorable report.
Thank you. Thank you so much, Senator, Mr. Chair, Mr. Vice Chair, and members of the Judicial Proceedings Committee. For the record, I'm Aisha Braveboy, State's Attorney for Prince George's County, and I'm here to testify today in support of Senate Bill 606. And this bill, as amended, will make necessary amendments to Maryland's organized crime statute to really reflect what we're seeing today on the streets regarding organized crime. In 1970, Congress enacted the RICO statute, and similar laws have been passed in many states. The law that was passed here focused on gangs and used that language when we passed that bill several years ago. But organized crime has really evolved in Maryland, and the evolution includes criminal organizations comprised of crews, or people who are more informally related, but are also benefiting from the same type of criminal activity. And so what we want to do as prosecutors is to increase the tools that we have to enforce the law against individuals who are committing offenses such as carjackings, human trafficking, gun trafficking, and various other serious crimes that are plaguing our communities. Recently, we have seen and experienced increases in these types of enterprises working in concert with each other to do things like commit carjackings. And often those who benefit from it were not the ones who were actually committing the offense on the streets, but those who are able to benefit upstream financially, like chop shops and other types of establishments that are benefiting from the terror on our streets. And so while we hold individuals accountable, we will continue to hold those accountable who commit the crimes. We also want to hold those accountable who are conspiring with others to terrorize our communities. And so the proposed amendments, again, this bill has amendments, and it would really just amend our current gang statute to give us more tools, more power, and clarify aspects of the law as it relates to organized crime and what we're seeing as organized crime on our streets. And so for these and many other reasons, we ask for a favorable report, and I'm happy to answer any questions that you might have.
Good afternoon, Chairman Smith, Vice Chairman Wallstrecker, and esteemed members of the Judicial Proceedings Committee. I am Perry Paler, Deputy State's Attorney for Prince George's County, and I'm here in support of Senate Bill 606 to amend Maryland's organized crime statutes. Part of my duties as Deputy State's Attorney includes managing the Guns and Drugs Unit and the Major Crime Units. These units prosecute gun trafficking, fentanyl distribution, and carjacking cases, respectively. As mentioned by Madam State's Attorney, adding the proposed amendments to the existing statute establishes clarity in the law and provides prosecutors with the tools needed to fight organized crime. Specifically, these amendments, as proposed, will allow prosecutors to indict multiple members of a criminal organization, gang, or crew, even in a situation where they were not present when the underlying act was committed. Prosecutors must show that all persons in the indictment benefited from the ongoing criminal enterprise. As currently constructed, it is unclear whether persons who benefit financially or participate tangentially with street crews engaged in criminal activities can face criminal or civil exposure pursuant to Maryland Criminal Law, Section 9-804. Prince George's County has experienced distribution of opioids in our public schools in the form of counterfeit oxycodone pills laced with fentanyl. These counterfeit pills are being manufactured and distributed by adults engaged in drug trafficking to our young people. Passage of this bill will allow for prosecutions of all persons engaged in trafficking, including those who are benefiting financially due to investing, advising, or directing drug traffickers in their trade. As we continue efforts to shape the best version of Maryland's organized crime statutes, we believe the following suggested amendments would efficiently address deficiencies in the existing statute and again allow for the prosecution of organized activity occurring in Maryland. For the foregoing reasons, I respectfully urge a favorable report. Thank you. Good to see you.
Mr. Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator and the Executive Director of the Maryland State's Attorneys Association. I've been prosecuting cases since 1984. Here in favor and asking for a favorable report is the Senate Bill 606. I want to thank our State's Attorney Aisha Braveboy and thank you, Senator Muse, for sponsoring this bill. It is certainly a tool that we need in the toolbox. It gives us that extra advantage that we don't have before, as Ms. Braveboy and Mr. Paler indicated. And for those reasons, on behalf of the Maryland State's Attorneys Association, we ask for a favorable report. And we're happy to answer any questions. Thank you.
All right, questions from the committee. Senator James.
Yes, to anybody just spoke. Is it fair to characterize the bill as a little RICO bill? And I know a little bit about the legislation, its history, and what we did prior
Yes.
in Maryland. And the reason I'm asking is we had a lot of difficulty getting some of these earlier iterations that are now on the books passed. So the reason I'm asking whether it's very similar to Little Rico is because then opposition and ambiguities have sort of been worked out by a lot of court cases across the country.
Sure. And what I would say is that we work very closely with the Office of the Attorney General to craft these amendments. And really, this is more of an update to our current gang statute that really clarifies the ability to prosecute forms of organized crime that don't look exactly like gangs. So as proposed, the original bill would have done a little bit more, would have been kind of more of a RICO statute.
Okay.
This bill really just clarifies what we currently have in statute and gives us stronger tools to be able to prosecute what we're seeing on the streets.
So it's not identical to a Little Rico bill. You've amended it to be more targeted to what you're seeing. So the question is, would leaving it as a Little Rico bill have prevented you from targeting the issues that you're seeing right now?
So this will get us there. I think that the RICO bill that we had proposed, there were some conflicts in the law between the gang statute and what we were proposing. And what we thought is that we could get there really by just massaging the current statute. It would essentially do the same thing. And so that's the route we chose because I think, number one, it will cut down on the opposition because this is what we currently have on the books. We're just strengthening the tools to what we're seeing, on our streets today.
And just one last question, by amending it to be more targeted and not being broader, and I support RICO and Little
Thank
Rico, but so it not being broader, can you all sort of attest to us that there aren't other criminal organizations that were going to be left untouched because we've more narrowly drawn the bill?
No, this is really expanding the definition of what organized crime looks like. So instead of just focusing on a gang with that hierarchical structure and all of that, this gives us that broader, a broader definition that we are looking for.
Thank you.
Thank you.
Thank
Mr. West.
Thank you, Mr. Chair. This is a very long 29-page and very complicated bill. I guess, Ms. Braveboy, maybe I should talk to you.
Yeah.
Either that or the sponsor, but since you're up there, I'll pick on you. And I think we're
But
gonna.
the amendments, the amendments, I think, streamline it, and it's not 29 pages, correct? The amendments are much shorter. And I don't know if you all have those.
Is this Bill 606? Recon? Yeah, 606.
Yeah, so there are amendments to the bill. I don't know if,
Maybe I guess I haven't seen the amendment.
yeah, the amendments are, you have them? Okay.
Oh, you have them. Okay. All right. So I'll have to look at those. Is section 906 still in the bill with the amendment? Or has that been taken out?
Senator, yes. At first, we started out with a RICO bill, then we moved to amend the current Maryland organized crime statutes found under Section 9, Article 8, 801 to 804 of the existing organized crime statutes. And those are our amendments.
Okay, I just, it's going to take me a while to digest this. And so you'll have to excuse me, but I'm looking at section 9-906. That leaped out at the beginning. This is like, it looks like an attempt to dragoon the Chief Justice of the Maryland Supreme Court into doing things.
Yeah, that part has been amended and it's no longer part of our proposed legislation.
Okay, good. That's good. That's going to help. Thank you very
Yeah,
much.
I was gonna say, I know that the judiciary wrote a letter of opposition, but I think with the amendments that addresses their concerns with the
Okay,
bill. So we're
I will
not directing the.
Promise you that
judiciary.
as soon as I get a moment, which may be a month from now, I will go back and very carefully read this bill.
Thank
Thank
you.
you.
But just stick with the amendments because we'll try to get a reprint of the bill with the amendment. Thank you. And we are happy. We know that the amendments are, that you may have just gotten them today. So we're happy to meet with you all one-on-one if you need additional information.
And that was my concern. Actually, I was going to ask you about the judiciary's concerns, and that was one of them. And so,
Yeah.
I have not seen the interlineated copy with the amendments, but we'll check it out to make sure. Is it possible you could get the judiciary to weigh in again on the new amendments?
Sure, and they may not have a position, they may
Yeah.
take no position because it doesn't really affect them.
Got it.
Yeah.
And dragoon, that's the word of the day. That's a good word. All right. Further questions from the committee? All right. Thank you all very much. Good to see you all. All right, that will conclude the testimony for the proponents of 606. We'll now switch to the opposition panel. And I think we have in person is Deborah Procaccio here. All right, and then we've got one virtual participant. Mr. McAvoy is not here. All right, he must be testifying virtually in another committee, which I'm sure he is. All right, so with that, that'll end the hearing for Senate Bill 606. We'll now move on to Senator Muse with Senate Bill 755.
Working state attorney to come back, and part of the panel, Jessica Garth from the State Attorney's Office and Nicholas Leonardi from the State Attorney's Office. This bill is very succinct and to the point. SB 755 as amended, and they will share the amendments, would prohibit a law enforcement officer or a correctional employee or court-ordered services provider from engaging in sexual activity with a person in their custody. Also, if convicted, SB 755 would change the act to a felony instead of a misdemeanor, and the defendant would be subject to imprisonment of up to 10 years or a fine up to $3,000 or both. Now, no one that is in the custody of an officer while they are in their official capacity should be forced or subjected to any sexual contact whatsoever. We cannot tolerate these offenses and behavior by persons who take an oath to protect the community. Some recent incidents that are included and that bill is modeled to address: a case in 2018, a 6-year veteran officer forced an undocumented Latina woman into engaging in a sexual act in exchange for evading a ticket or arrest. In October of 2022, a Maryland sheriff was charged with second-degree rape and assault of an individual while in custody. In 2020, an officer from a local municipality sexually assaulted a 19-year-old woman while in custody after a traffic stop. And I'm going to let my panelists talk more about this case, as they were the ones to try this case in January of this year. In closing, let me say this: there are many, many wonderful things, great things. We could not make it in our society, be it in any semblance of peace, without our police officers. I am a law enforcement police officer supporter all the way, or public safety supporter all the way. Unfortunately, there's a small number of persons who will do things that will tarnish everyone. And this is just another tool, hopefully, to strengthen it so that it would be a deterrent. It would deter law enforcement officers, correctional officers, or court-ordered service provider from committing such an act. Therefore, I urge a favorable report for SB 755 as amended. I'll let the panel go, and then any questions you have of me or us, please do so. Okay, State Attorney.
Senator. Thank you so much, Senator Muse. We really appreciate you. And again, for the record, I'm Aisha Braveboy, State's Attorney for Prince George's County, here to testify in support of Senate Bill 755. I will allow my team here, my ABLE team, to really talk about all of the specifics of the bill and why we need it. What I wanted to just share with you is that, when we look at our second-degree assault statute, which is a misdemeanor assault statute, an individual, if found convicted, could face up to 10 years in prison, But for someone who is forced to have sex in custody for that offense itself, sex in custody, currently the penalty is only 3 years. And so I think that we can all agree that an assault, while it is a terrible crime, It is a lot different than being sexually assaulted by an officer in a compromised position where consent cannot reasonably be given. Because that officer has the ability to continue to detain you, to arrest you, to charge you. And so it is a very, it is a horrible crime, but it's not treated any more harshly, or it's not treated as harshly, quite frankly, as a second-degree assault, which could be a threat of force, a slap, a push, a threat of force. So if you really think about it, we have not done ourselves justice in this state by allowing this offense not to be at the level that it needs to be. And so this bill would provide enhancements to in terms of the penalties for the commission of this crime. So thank you very much. And I believe that Nick Leonardi will go next. Thank you.
Mr. Chairman, members of the committee, good afternoon. My name is Nick Leonardi, and I'm an assistant state's attorney in the Public Integrity Unit of the Prince George's County State's Attorney's Office. I'm here today in support of Senate Bill 755 on behalf of State's Attorney Aisha Braveboy. In January of this year, I tried a case against a police officer who pulled over a 19-year-old woman who was speeding, trying to get to her injured infant son. He arrested her for disorderly conduct, and he brought her back to his police station in handcuffs, where he had sex with her in exchange for her freedom. That officer was charged with first and second degree rape, third-degree sex offense, and sex with the person in custody. But after a 4-day jury trial, was convicted only of sexual contact with the person in custody, which under current Maryland law is a misdemeanor that carries a maximum of 3 years in prison. If that outcome seems inadequate, the fault may lie with current Maryland law. HB 1292, which in 2018 criminalized sexual contact with a person in police custody, was an important first step, but did not go far enough to hold police officers accountable. When a police officer who is in control of a person's freedom uses that freedom as a sexual bargaining chip, a 3-year misdemeanor conviction is simply insufficient to redress the harm done to the victim and to the community's faith and trust in law enforcement as a whole. It's for that reason that I ask for a favorable report on Senate Bill 755. Thank you very much.
Good afternoon, Mr. Chair and members of the committee. My name is Jessica Garth. I am the Chief of the Special Victims and Family Violence Unit at the State's Attorney's Office for Prince George's County. I'm here with my boss, Ms. Braveboy, and my colleague, ASA Leonardi, and I'm happy to be here. I do want to also just point out that while the panel in front of you is Prince George's County strong, this bill does have wide support. If you'll consult the written testimony, there are other prosecutors who I know submitted written testimony as well as advocates. I really can't add anything to what Nick and Ms. Braveboy had said, but I do want to lend my support. I also stand here representing the Maryland State's Attorneys Association, and we do have their support as well. I'm here to answer any questions that you might have, and I urge a favorable report on this bill. Thank you.
All right, seeing none, thank you all very much. Okay. Excellent. So that'll end the hearing for Senate Bill 755. We'll now move on to Senator Bolden, since so we'll go to Senate Bill 568. How about that? 568.
I could bring up my panel. Are you? User. Thank you, Mr. Chairman. Esteemed colleagues, for the record, Senator William Fulton, District 4, Frederick County.
Before you today, I have Senate Bill 568, criminal law threat against a state or local official, being that of a first responder. The purpose behind this bill is to bring forward to light that our first responders who are at their most critical and vulnerable moments are vulnerable while rendering aid. Our nurses, our physicians, our EMTs, our firefighters, they're coming there at our moment of need. And there are times when they are interfered with and they are assaulted, and there is no heightened penalty in regards to this type of assault against these first responders. So this bill, in short, defines a first responder, obviously, like I said, as a firefighter, an EMT, a paramedic, a rescue squad member, or a nurse or doctor who provides emergency services. And in allowing us to do our part to take care of those who are taking care of us is an important element and responsibility we have in this body. And I would encourage you and implore you for a favorable report once you hear the testimony before you about the importance of having safeguards in place for those that provide this very important critical care to us, to our family members, and that they also have protections for them. So with that, I would ask for a favorable report, and I'll turn it over to my panel.
I am Jane Kirschling, Dean of the University of Maryland School of Nursing, and I'm here today to provide support for Senate Bill 568. Violence and threats of violence against medical and healthcare personnel is an increasing problem. In the United States, the healthcare workforce accounts for 14% of all workers. However, they experience roughly 75% of all non-fatal intentional workplace injuries. A widely cited 2022 study on workplace non-fatal violence early in the pandemic indicated that between February and June of 2020, 44% of surveyed nurses reported experiencing physical violence from a patient, a visitor, or a family member, and 68% reported verbal abuse. Among those reporting physical violence, 21% experienced physical violence 2 or to 3 times within the period. And among those reporting verbal abuse, 28% reported experiencing it 2 to 3 times during that period. The authors indicated that violent, non-fatal incidents were already an increasing trend from 2011 to 2018. They noted that compared to private industry, workers in hospital settings were 8 times more likely to experience non-fatal violence-related injuries than other persons. In a 2023 environmental scan, the National Council of State Boards of Nursing outlined the increasing threat. And I quote, "Although recent deaths from violence at healthcare facilities bring this threat front and center as extreme cases of workplace violence, non-fatal incidents of violence occur at an alarming rate. This violence not only affects the victim's physical body, but also the mental health of those whom the violence is perpetrated against, as well as those around the victims." As we consider this complex issue related to the current shortage of nursing personnel, it is important to realize the impact of workplace violence on decisions regarding whether or not to remain in or enter the nursing workforce. Therefore, I offer the University of Maryland Schools of Nursing full support for Senate Bill 568. Thank you.
Excellent. Thank you very much. And it's my apologies. For the next witness, could they come up to the podium just so the camera can see? Thank you very much.
Good afternoon, Chairman Smith, Vice Chair Waldstreicher, and committee members. My name is Caroline Doyle, and I am testifying on behalf of the Maryland Emergency Nurses Association in favor of SB 598. The National Institute for Occupational Safety and Health defines workplace violence as violent acts, including physical assaults and threats of assaults, directed towards persons at work or on duty. OSHA further reports that even if no physical injury takes place, threats, abuse, hostility, harassment, and other forms of verbal violence can cause significant psychological trauma and stress. Verbal violence often quickly escalates into physical violence. Both types can significantly interfere with saving lives. One simply cannot give and provide CPR to a patient in cardiac arrest and de-escalate a loved one who is spewing cuss words and insults and threatening to kill us. At least one team member must stop doing their job to deal with this threat. As a charge nurse in a large emergency department in Southwest Baltimore along the I-695 and I-95 corridors, I can attest that threats and physical violence directed towards emergency physicians, emergency nurses, and other first responders have increased in frequency and severity over the past 3 years. This increase has occurred nationally and is being called a national epidemic. Threats against first responders in Maryland have worsened due to Maryland having the longest ER wait times to see a doctor of any state in the nation. Maryland is also suffering from a severe shortage of healthcare workers, as documented in the Maryland Hospital Association's 2022 State of Maryland's Healthcare Workforce Report. The long waits for care make patients and their family members angry, and they act out. Threats and violence towards emergency physicians and emergency nurses are one of the documented reasons why first responders have either changed specialties or have just flat out quit the profession. Thank you in advance for your favorable review of SB 568. Being able to address threats to safety real time will help the citizens and first responders in the state of Maryland. Thank you.
Good afternoon, Chair, distinguished members. For the record, my name is Bob Phillips. I'm the Legislative Chair for the Maryland State Firefighters Association. Career-wise, I was a volunteer, still am, for 45 years. The last 10 years, I was in the Chief's office as a command officer. I say that because I can attest to what happens out on the street when you're trying to be a first responder doing your job. I've had my life threatened. I've been fussed at, cussed at, and everything else. It's all part of the job. The MSFA is fully in favor of this bill. We would like to, with amendment, add the first responders, and that's the 911 dispatchers. They're also called specialists and call takers. I was married to a specialist. She preferred dispatcher, so I'll use that term. I spent many hours over the years in the call center with her and her team. I listened to a lot of people get very irate, and it's understandable. People are in need of help. And when they do not feel like they're getting the help they need or quick enough, it does turn to anger. There is some understanding here. But like was said earlier, it can turn violent. The MSFA is fully in favor of this. And we would like to see you with a favorable report with the amendment of adding the 911 dispatchers, call takers, or specialists, whatever you want to call them. If you will look, I don't think you're going to find a universal definition for first responder. Every bill has a different definition. We'd like to see the first responders added to this bill. Thank you very much.
Hello again. My name's Lisa Tenney, and I am testifying on behalf of the Maryland Emergency Nurses Association, and we are in favor of SB 598. The question of the day is, why should first responders receive special protection under the law alongside you, state and local officials, when threatening behaviors interfere with our ability to do our job? And the answer is time. Firefighters, paramedics, EMTs, other rescue squads, ER docs, and ER nurses, we run in and we save lives, right? We are the ones who come to the rescue of Maryland's adult and pediatric citizens when they are victims of fire and trauma, life-threatening surgical and medical emergencies, and psychiatric emergencies. Our success in saving them, or at least minimizing their disability, often depends on time. Every second counts. In a heart attack, blood flow needs to be restored to the heart muscles. In stroke, blood flow needs to be restored to the brain. Limiting tourniquet time to just 2 hours to stop bleeding saves lives and limbs. And in trauma, the golden hour of trauma of getting a trauma patient to definitive care provides the patient with the best chances of survival and good neurological outcome. Not to mention, when somebody is not breathing, permanent brain damage can occur in 4 minutes, with death in 4 to 10 minutes. Time matters. Interference by threatening people, and believe me, they do, when first responders are trying to save lives, causes delay in care and response times. At least one caregiver is taken away from the team that's trying to save this life to try to de-escalate the patient who's making the threats and remove them from the scene. The person causing the interference really needs to be held accountable. So 598 will accomplish this in real time, and thank you in advance for a favorable, hopefully bipartisan review. Thank you.
So thank you very much for your testimony. Questions from the committee? All right, seeing none, thank you all very much. Thank you. All right, we'll hear, the rest of the participants appear to be virtual, so we're gonna pipe in Emily Pepin, Lisa Fisher, it's not here, it's Megan Bunn.
That's for a favorable, hopefully bipartisan review.
And if you're coming into the Zoom room, if you could mute or close down your tab from the YouTube feed. And Ms. Hightower, I see you there, so you're up first. Welcome. I think you're good to go.
Good afternoon, senators and committee members. I'm Erica Hightower, a Maryland emergency nurse, speaking on behalf of myself in favor of Senate Bill 568. Since starting my nursing career approximately 18 months ago, I've been physically assaulted twice and verbally abused more times than I can count. While providing patient care, I've been called racial slurs and other profanities. I've also been sexually harassed by a patient. I'm currently not able to work due to an injury sustained when I was assaulted in November of 2022. I'm currently awaiting surgery for this injury, and I expect to return to work in 4 to 6 months. This means I will lost almost a year of my professional life from being able to provide altruistic care to those in need. Additionally, this injury has changed my personal life as my dominant hand remains partially disabled. I've witnessed patients threaten to wait outside for my colleagues to return back to the facility to inflict violence, and I've even witnessed patients threaten to use medical equipment as a weapon. Furthermore, my colleagues and I are responsible for documenting patients' belongings. We've had many incidences where nurses have had to confiscate knives and illegal drugs from patients and turn it into security. There is an unceasing list of inappropriacy first responders endure, and it's terrifying. These threats not only affect staff, but other patients as well. While security is usually present in the emergency department, the emotional toll remains overbearing. A sense of helplessness shadows each threat and causes mental and emotional distress. Patients who have a history of violence are currently identified by a red flag alert in their chart. While this brings awareness to the staff, it does not hold the patient accountable for their actions. The emergency room and its staff are considered the first line of care for many patients. It's our responsibility to protect and care for them. It's hard to protect our patients when we're not protected from threats ourselves. First responders deserve better protection. I love caring for patients and their families, but I feel powerless to the violence we are subjected to. I'm testifying in favor of Senate Bill 568 as it provides legal consequences that will hopefully discourage patients from abusing first responders. I'm presently coping with an injury sustained from workplace violence and anticipate this bill will prevent another from experiencing this distress. Thank you.
Thank you very much, Ms. Hightower. Ms. Bunn, you're up. Welcome.
Hi, my name is Megan Bunn. I'm an emergency nurse who serves the citizens of Maryland, and I testify today in favor of SB 586 to protect the section of providing care. Nursing has proven to be dangerous, and we must take these threats seriously. I hold active peace orders against patients because they have threatened the safety of me and my family. One patient threatened to kill me and my son. The fact that I'm a mother was not personal information shared with this patient. After hearing that threat, I looked into his chart only to find the patient lived 1 block away from me. After another patient, after being administratively discharged related to his behavior, the patient threatened to, quote, return to the hospital to, quote, take care of this bitch. The patient did return later that day. Thankfully, after evaluation, he was denied access. It was later revealed that the patient had existing warrants for his arrest for violence against healthcare workers and peace order violations. This incident was proof that these threats are real and they should be considered as such. A third incident, a patient punched me in the face, leaving my jaw bruised. Another patient has kicked me in the chest while transferring them to a stretcher. I am verbally harassed on a weekly basis by patients who are dissatisfied with their care. Violence towards me and my coworkers interferes with the safe and effective care. It has also caused us to lose staff amidst a severe nursing shortage in Maryland and nationwide. The process of obtaining peace orders is traumatizing. Like other nurses, I work in different ERs around the Baltimore area, and I need to file peace orders so I'm covered wherever I go. Attending weekly court visits only to discover that the offender has not been served or is a no-show takes time, and it wears on my mental health. Because this process is arduous and frustrating, many assaults against my colleagues go unreported and allow the perpetrator the opportunity to come back and threaten and hurt others. I save lives for a living. Mine deserves to be protected so I can continue to serve the citizens of Maryland. Thank you.
Thank you very much, Ms. Bunn. And Emily, Ms. Pepkin, you're up. Welcome.
Thank you. My name is Emily Pepin. I'm a Maryland ER nurse who works in South Baltimore City, Brooklyn Park. I'm speaking on behalf of myself, and I'm in favor of SB 568. Emergency nurses and physicians and other first responders are punched, kicked, stabbed, and threatened daily. Some first responders have died from their injuries, and if they don't die, they suffer emotional and physical trauma that drives them away from their services. Threats make us scared to walk to our cars after work. Threats make us afraid that a discharged, angry patient will linger in the parking lot. This is behavior we endure while working long hours in an already stressful critical care setting. My coworkers and I are yelled at, cussed at, and threatened daily. And triage patients are treated by acuity, not time of arrival. A non-critical woman became upset with me that she had to wait for hours. A man then decided to join her and became hostile towards myself. He threatened to fight and hurt me physically. While being removed by security, the patient said he would be back with weapons to harm the emergency department. Just last week, we had a patient state he was going to, quote, shoot up the ER. Another discharged patient chased me down the hall. Fortunately, another patient, my coworkers, and manager helped stop the patient. Another patient had told me I hoped I got pregnant and miscarried that child. Threatening events have occurred while we were intubating a 2-year-old in respiratory failure, and we are giving CPR and intubating a 3-year-old. These life-saving actions require several ER nurses and physicians. When a threatening patient is simultaneously demanding our attention, it distracts us. It interferes with the care of these critical patients. Think, how would you feel if your child, spouse, or family member was sick in an ER and needed life-saving treatment and there were not enough nurses to help? How would that impact the care given and the health of your loved one? It would delay care and cause us to make errors. This is exactly what happens as first responders when we are threatened. Time and attention are taken away from a critical care patient. While a peace order can be obtained after someone threatens to come back and harm us, we can use SB 568 during actual events. It is simple. Its threats and abuse from patients are tolerated, care length of stays worsen, and there's less first responders.
Excellent. Thank you very much for your testimony. Questions from the committee? All right, seeing none, that'll end the hearing and the testimony for Senate Bill 568. We'll now move on to Senator Carter. Is Senator Carter available? Okay. Then we go to all right, Senator Folden, we'll go to Senate Bill 744. 744. Yeah. I think it's a quicker hearing that way when the senator gets to. All right. So let's do Senate Bill 744 real quick because there's only 2 witnesses, and then Senator Carter is here, and then we'll go to Senate Bill 763.
All right, thank you, Mr. Chairman, esteemed colleagues. For the record, Senator William Folden, District 4, Frederick County. Here to testify on behalf of Senate Bill 744, the Penalties and Procedures Violent Firearms Offenders Act of 2023. Violent Firearms Offender Act of 2023 is a reintroduction of a bill that was passed in the Senate during 2021 and 2020, but died in the House. Is in the form that it passed in the Senate in 2021 and has bipartisan support in the Senate this year. In short, SB 744 raises using a firearm in a violent crime to a felony from a misdemeanor. It removes the drug dealer loophole where drug dealers receive a lighter sentence than someone convicted of the same offense. It increases the penalty for illegally possessing a firearm from 5 years or $10,000 on the first offense, or I'm sorry, it increases it to 5 years or $10,000 on a first offense and 10 years and or 10,000 fine thereafter. And it makes knowingly selling a firearm to someone that plans to use it in the commission of a crime a felony. SB 744 targets repeat violent offenders and gives prosecutors the tools to hold them accountable. Right now, criminals do not fear the consequences. Hopefully, that this bill can pass the Senate and finally be considered by the House would bring steps forward in our responsibility to protect the communities that we are elected to serve. We've done many, many things with justice restoration acts in the past, and it's time now to pass a measure for holding those accountable that prey on our vulnerable communities for these type of violent firearm offenses. And with that, I would ask for a favorable report on SB 744.
All right, seeing no questions from the committee for the sponsor of the bill, we'll now move on to the opponents of the bill. We have Mr. Brown, Gregory Brown.
Good afternoon, Chair and members of the committee. My name is Gregory Brown. I'm policy counsel at the ACLU of Maryland. And our biggest problem with this bill is the increase on penalties. And I'll read part of my testimony, if you will. So by expanding the crimes of violence statute, SB 744 is effectively a sentence enhancement. And enhanced sentences require that the state expand unjustified resources housing persons who may otherwise be appropriate for release. Moreover, no evidence indicates that there's a public safety benefit to increasing sentence lengths. Indeed, the evidence shows that more severe sentences do not deter crime more effectively than less severe sentences. More importantly, it's the certainty that someone will get caught that deters crime more so than the increased penalty. And that's the largest reason that we're in opposition to this bill. Also, a growing body of criminological research demonstrates that prison terms are not more likely to reduce, that longer prison terms are not more likely to reduce recidivism than non-custodial sanctions. For some offenders, including drug offenders, technical violators, and first-time offenders, studies have shown that prison can actually increase the likelihood of recidivism. There's also growing evidence that for many offenders, adding days, months, or years to prison sentences has no impact on that. For the foregoing reasons, we oppose this bill.
Questions from the committee? All right, thank you very much. Thank you. And with that, that'll end the hearing for Senate Bill 744. We'll now go on to Senator Carter, Senate Bill 763. Senator Carter, you're up.
Thank you, Mr. Chairman and members of the committee. This is a bill that I've brought on behalf of the city administration. It resembles closely a bill that I sponsored last year in 2021 when we passed our package of police reform. We included in police reform the establishment of police accountability boards. This is related to the underlying legislation that we passed. Last year, I had a bill that would have ensured that the current duties and responsibilities of the Baltimore City Civilian Review Board are transferred to the Police Accountability Board. This bill seeks to do something similar, and the city will testify as to why we need the bill. It has the intent of expanding civilian participation and oversight. I do have one concern regarding the Civilian Review Board. It is my belief that we need to explicitly transfer the investigatory powers and subpoena powers to the Police Accountability Board. I know that the city has a different view. They think it should just be generally under the Office of Equity and let the city council pass an ordinance. They're going to talk about that. I just wanted to lay it out on the table where we are. It's pending a vote in the delegation at this point. Thank you.
Good afternoon, Mr. Chair, members of the committee. My name is Nina Themlis, Interim Director of the Mayor's Office of Government Relations. Here to testify on behalf of the Baltimore City Administration in support of Senate Bill 763. I would like to thank Senator Carter for introducing this bill on our behalf. The bill provides for the responsible and gradual sunsetting of the Civilian Review Board while preserving and enhancing its existing investigatory and subpoena powers within the City of Baltimore's Office of Equity and Civil Rights. The agency that's currently responsible for overseeing and staffing the Civilian Review Board, the Police Accountability Board, and the Administrative Charging Committee. The Civilian Review Board was created by state law in 1999 as the only civilian body with oversight of the law enforcement agencies of Baltimore City. Although the CRB is currently the only entity with an independent investigatory authority, the enabling legislation limits its jurisdiction to 5 allegation types and requires complaints to be filed on a signed form within 1 year of the incident. SB 763 maintains this investigative model of oversight while removing administrative constraints and expanding jurisdiction to all complaints involving a member of the public. You'll next hear from Marielle Chatinia from the Baltimore City Office of Equity and Civil Rights, who will speak to the specific operations of the Civilian Review Board, the Police Accountability Board, and the Administrative Charging Committee, and why this legislative change is needed. With that, I request a favorable report for Senate Bill 763. Thank you.
Good afternoon. Thank you. My name is Marielle Chatinia. I serve as the Chief of the Police Accountability Division in the Office of Equity and Civil Rights, where I oversee the Civilian Review Board, the Police Accountability Board, and the Administrative Charging Committee for the city. I'm here today to ask for your support on SB 763, which abrogates the CRB while maintaining its investigatory and subpoena powers with expanded jurisdiction. As Nina said, the CRB only has jurisdiction over 5 types of misconduct complaints, and that complaint must be on a signed CRB form. There are approximately 700 cases of police misconduct involving a member of the public received annually, and about only 50 of those meet CRB criteria. This bill expands the investigatory power to all complaints of police misconduct involving a member of the public. This bill maintains the powers of the CRB that are not currently assigned to any other entity in the city, and then allows our city council to determine how these responsibilities are reallocated. This is both in the spirit of local control and for a very practical manner of assigning those duties to the PAB. Our PAB has 17 members who did not sign up for such an intensive caseload that we anticipate will take several days a month. It would be prudent to assign the CRB duties and powers to a subcommittee of the PAB so those members have the time to do that work in a manageable way. The city's position last year was to provide these powers directly to the Administrative Charging Committee, but that position has changed. The City Council created the PAB by local ordinance, and they must be the ones to give these powers to a PAB subcommittee. If the ACC received these powers instead of the PAB, the ACC would be given 2 separate investigatory files, one from independent investigators and one from internal affairs. 2 case files contradicting one another could create unreconcilable conflicts at the appeal level. This independent investigatory power must be given to a subcommittee of the PAB by the Baltimore City Council to avoid these potential conflicts and maintain implementable civilian oversight. SB 763 holds these powers within the Office of Equity and Civil Rights, the city agency in charge of supporting and staffing the CRB, the PAB, and the ACC, providing time to gradually abrogate the CRB and allow the City Council to reestablish these duties to a subcommittee of the PAB. We ask for your support on SB 763. Thank you.
Excellent. Thank you very much. Questions for the committee for this panel? Okay, I got it. Excellent. Senator West.
Thank you, Mr. Sponsor. Haven't we had another bill or 2 this year trying to set up parallel investigations of police? So we already have their Internal Affairs Division, which investigates police. And now we have the Attorney General who investigates police if there's a death of somebody or critical injuries. I thought there was a bill earlier this year to create yet a 3rd organization that's going to investigate police. Do you recall that?
Take the question for, so there's been a difference of opinion among some legislators and advocates and the city administration about how to transition the current powers of the Civilian Review Board. And so the bill that we heard before was my bill, and that bill would expand those powers that they have to currently investigate. It's not adding anything new. They already have they're like the oldest since 1999. They've had these powers to investigate and subpoena powers, but their categories were limited. So in creating the police accountability boards, it's some of our belief, my belief, that those powers should be expanded and transferred to the Police Accountability Board, which we passed in legislation, as you know, for jurisdictions to set their own boards. I guess the sticking point, and this is probably important, not just for Baltimore, but maybe even across the state ultimately, is the difference between an administrative charging committee and the Police Accountability Board. The wisdom behind creating the Police Accountability Board was not to give the people less power than they currently have with the Civilian Review Board, but more. And so the administrative charging committees, they are limited currently to the internal investigations, and they make those decisions about whether or what should be charged or not. But what the goal of the legislation to strengthen police accountability boards was to do what the Civilian Review Board does, but even more. If this answer is getting long. So it's not creating anything new. The issue is the distinction between what is the role of the Police Accountability Board and what is the role of the Administrative Charging Committee. And the only way to have true independence and civilian oversight, in my view, is to have powers in the Police Accountability Board outside and independent of the internal investigations process.
Right. I think I'm more confused now than I was when I started.
It's not creating anything new. It's the philosophy about who do you think is in the best position to have an independent investigation outside of the police investigating and policing themselves? And
So
we
have the
believe that
Internal
the people
Affairs
should have the power.
Division of the police department. We have the Police Accountability Board. We have the Civilian Review Board. We have the Attorney General.
The
All of
Attorney
whom-
General is not really in this because he's limited to those cases of investigation that are specifically when law enforcement kills someone, the police involved killings. And that is generally designed to determine, should there be a criminal prosecution? These are just administrative charges for officers. Should the officer be disciplined?
Okay, well, so what answer does the city want? Does the city,
The city-
the city wants the Internal Affairs Division to continue to investigate complaints against officers?
Yes, and nobody doesn't want that. That's still the case. But right now,
Well, what about these other two? What about
Baltimore,
the
so this is-
Accountability Board on
this is
one
what
hand, the
shouldn't be
Civilian Review
confusing.
Board on the other?
I'm trying my best to explain it.
Okay,
The Civilian Review Board, as was testified to, has existed since 1999. It has power to investigate. It has power to subpoena. But all of these years, those powers were limited to 5 restricted areas: excessive force, I can't remember, kidnapping, what do you call it? I can't remember at this moment, but 5 very limited categories that don't cover everything. And one of the reasons it didn't work is that police would just simply characterize something in a way that fell outside of those areas that it had the power to investigate, to say, oh, it's not for the Civilian Review Board because it's discourtesy, not excessive force or whatever. So when we created the Police Accountability Act and we created the ability, we enabled jurisdictions to create a Police Accountability Board, this is where the sticking point is. Some people, perhaps the administration has the view that they want to limit the powers of the Police Accountability Board to have even less than what the Civilian Review Board has.
The mayor.
Yes.
Okay.
Okay. That would give the Police Accountability Board less power than the current Civilian Review Board has. And I don't agree with that, but that's what this bill doesn't even say that. This bill says that the Civilian Review Board would end, that the Police Accountability Board would have oversight over more categories than what the current Civilian Review Board does. That's where we agree. Where there's a disagreement is this bill says that the Baltimore City Office of Equity and Civil Rights all of this would fall under that office, all of it. Administrative Charging Committee, Investigations, Police Accountability Board. Civilian Review Board would exist no more, okay? And then their bill says that Baltimore City would then pass an ordinance to determine how those powers would be distributed.
You say their bill, you mean this bill?
Yes, this bill. But you asked in the context of another bill, so I was trying to distinguish. The other bill was just my individual bill. This is the city administration bill.
Last question. Hearkening back to a question I asked about 2 weeks ago in another city bill about policing. Does the city have its act together on this? Is everybody on the same page? Does the mayor and the city council and everybody who's in a position of leadership in the city agree on what should happen? Who should do the investigation?
We're very close. So everybody agrees to the current law that exists all over the state, that where administrative charging committees are located, where they are everywhere now, they will be. Internal affairs that's always done their own investigations would still be the body that would, the entity that would do the investigations. The issue in Baltimore is specifically that the Civilian Review Board has always had independent investigatory power, and we don't want to lose that. We want with the creation of the Police Accountability Board, we want that power to still be independent and not have a board or everyone have to rely on that one police investigation. Has been the issue.
Okay.
Do you understand?
I understand better than I did in the beginning. Thank you.
It's like ping pong. All right. Additional questions for the sponsor of the bill or the panel? All right, thank you all very much. All right, so that'll conclude the testimony for the proponents of the bill. We'll now switch over to our opposition panel. And we'll switch over to, is Mike Davey here? Is Janet Emanuel? And Clyde Boatwright. So this is unprecedented and unusual. Oh my gosh. This bill has managed to unite the FOP and the ACLU on the same page. That's why I paused. I was like, this can't be happening. All right. All right. Well, Mr. Davey, you're up first.
Thank you. Good afternoon, Mr. Chair, members of the committee. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police and General Counsel to Baltimore City Fraternal Order of Police Lodge 3. We're requesting an unfavorable report on Senate Bill 763. The passage of this bill will only affect law enforcement officers or agencies within Baltimore City. As you know, in 2021, the Police Accountability Act was passed for civilian oversight and transparency as it pertains to police misconduct. This bill would authorize the Baltimore City Office of Equity and Civil Rights to review and investigate simultaneously with the Baltimore Police Department Public Integrity Bureau, which is their internal affairs, each complaint it deems appropriate and report its finding directly to the Administrative Charging Committee. Today, the CRB, the Citizen Review Board, have 5 areas that they can investigate, and that's excessive force, abusive language, harassment, false arrest, and false imprisonment. Those duties, the way I'm reading the bill, will then go to this this Office of Equity and Civil Rights. The passage of this bill will now allow, as Senator West just said, 5 entities to investigate police misconduct. You could have, if the incident was a result of death or likelihood of death, the Office of Attorney General's office would do that investigation. Baltimore Police Department's Public Integrity Bureau will do an investigation. The Administrative Charging Committee that is already in place has the authority to review internal affairs investigations conducted by PIB, review body-worn camera footage, request additional investigative steps, order the officers to appear before it, and has subpoena power. Really, the question is going to come down to, what does the police department or the ACC do when you get 4 or 5 conflicting findings? The only person that's going to benefit from that will be the officer who's accused in the misconduct. Because with 5 different findings, it's going to be very difficult, even under the preponderance of evidence, to find that individual guilty. Based on the information provided, I'll stand for any questions. We would request an unfavorable report on Senate Bill 763. Thank you.
Whomever wishes to go next.
I'll still stay.
Good afternoon. For the record, my name is Janet Emanuel, Public Policy Director with the ACLU of Maryland, here opposed to SB 763 for different reasons. We continue to oppose the city's efforts to undermine community oversight. SB 763 seeks to give the illusion of independent accountability by repealing the Civilian Review Board and giving the Office of Equity and Civil Rights, a city agency, independent investigatory powers and the authority to share its findings with the Administrative Charging Committee. The National Association of Civilian Oversight of Law Enforcement says one of the most important and defining concepts of civilian oversight of law enforcement is independence, both structural and political. Sunsetting the CRB and granting its independent investigatory power to the Office of Equity and Civil Rights, a department under the supervision of the mayor, who also supervises the police commissioner, is a conflict of interest. The CRB is an independent agency. The Maryland Court of Special Appeals established that in 2006. Therefore, the CRB is not an agency overseen by the mayor, city council, the Baltimore City Police Department. As such, the CRB should not be sunset until the Police Accountability Board is granted the same status and powers as the Civilian Review Board. Passage of SB 763 would only increase community resentment and distrust as residents go to the board to seek redress, yet end up with very little. Furthermore, the passage of this bill will mean that Baltimore City will have an even weaker community oversight structure than it did prior to the passage of the repeal of the Law Enforcement Officers Bill of Rights. And so for those reasons, the ACLU and the Maryland Coalition for Justice and Police Accountability urge unfavorable report on SB 763, and I'm happy to answer any questions. Thank you.
Thank you, Mr. Chair, members of the committee. My name is Clyde Boatwright, and I'm the president of the Maryland State Fraternal Order Police, urging a unfavorable report for Senate Bill 763. Police officer for the last 23 years in the city of Baltimore. I think about a scenario in which Council Mike Davey talked about where there could be 5 different investigations. As you know, in Baltimore, there are many different police departments, and we all respond to the same incidents at the same time. And so that number of parallel investigations could grow, having multiple agencies responding to the same event. I know 2 years ago in 2021, my gift from the COVID years is now eyeglasses, because we spent many hours talking about police accountability on Zoom. And we narrowed it down to a singular focus about being having police officers accountable to the public. And from that, we developed collectively as a group, with the help of members of the public, that the Police Accountability Board exists. And so we think that there is accountability for police who are accused of misconduct, and that parallel investigation done by, the singular investigation done by the Internal Affairs Division and reviewed by the Accountability Board is sufficient. And that's what the law says back in 2021. And we would like to see fruit from that labor of our many hours of working to try to get this thing right. So with that, we will urge an unfavorable report.
Thank you very much, Senator Carter.
Thank you, Mr. Chair. I'll be brief. Mr. Davey and Mr. Boatwright, my question, or it's really a point of clarification, but I can pose it in the form of a question. So you've both testified that this would create a mechanism whereby there could be 5 separate investigations. But in fact, that is not true. It does not add any additional layers of investigation from what already existing before 2021, when there was an internal affairs investigation within a department. There was a charging committee, but often those charging committees were sometimes they might bring in a civilian if it was a serious case, but outside of that, it was like internal. It was like the members of the police department on the charging committee. So what our law did is it said, oh, we're going to add civilians to the charging committee. Same investigation, adding no new investigations. Same investigation always existed pre-2021 and post-2021 The Civilian Review Board in Baltimore City had the power to have that independent investigation. And so all that this bill does is it will sunset the CRB, will expand those categories of investigation and give that to the Police Accountability Board. No additional investigation that would already existed under the law. And then the other thing, the AG, of course, is standing in the stead of the prosecutor in terms of determining whether or not to bring criminal charges, which has always existed, just existed in the state prosecutors, local prosecutors, and not the Attorney General. Isn't that true?
So the Office of Attorney General's office has the authority now to investigate those cases involving citizens' death and likelihood of death. They do criminal investigations. Those criminal investigations are then turned over to the police department if no criminal charges are brought for additional internal administrative investigation. So that's number one. We then have the the Baltimore Police Department's Public Integrity Unit, which is internal affairs. That's another separate investigation. The Administrative Charging Committee today under the law has the authority, as I stated, to review the internal affairs investigations conducted by PIB, review body worn camera footage, request additional investigative steps, order the officer to appear before it, and has subpoena power. That's already in the law. Additionally, now with the passage, if Senate Bill 763, now that will give the Office of Equity and Civil Rights the ability to conduct its own independent investigation on anything they deem appropriate. They're not limited to the 5 categories.
Right.
So this would give another full investigation. That's 4. And Senate Bill 285 that was introduced earlier this session gave the Police Accountability Board the power to investigate independently with subpoena power. So that's 1, 2, 3, 4,
So I think
5 investigations.
I think you're misreading it. I do, because I think clearly there wouldn't be 2 different investigations in Baltimore for a Police Accountability Board and the Office of Equity and Civil Rights. Police Accountability Boards are under the Office of Equity and Civil Rights. So let me be clear. We can discuss this further, but there's still the same internal investigation. It's just that administrative charging committee reviews that same internal investigation that was always there. That's not a new investigation, but there is review power. They can say, we don't think you did a good job, and go back and, ask these people some questions or something. That's not a whole separate investigation. Second, the it's either or. It's the Police Accountability Board or the Civilian Review Board. Civilian Review Board is not going to exist anymore. Powers would ostensibly go to the Police Accountability Board. That's 2 that's already existed. And then the Attorney General, of course, standing in the stead of a prosecutor, is the same type of investigation that's always existed. So that's why I say I think that you're misreading it. I do understand that you're saying there could be another layer if they find that something needs to be continued and they can send it back. But as it stands now, this doesn't add any additional layers. All it ostensibly does is expand the categories of investigation to whatever entity should then stand in the stead of the Civilian Review Board. That's what it does. It's still the same 3.
And as you stated, we probably don't agree, because the way I read 2 separate bills, they're 2 separate investigative entities that can investigate it. I've been defending police officers for 24 years now. If I'm not good at anything else, I'm good at dissecting internal investigations. And if you give me 3 or 4 or 5 of them, it's going to be very difficult for any trial board to convict an officer of misconduct due to the conflicts that are most likely are going to be found in those investigations.
Just to be clear, the trial boards, if they always have existed, have always relied on the internal investigation. They have never relied on the Civilian Review Board investigation. In fact, one of the reasons that led to the need to do this in police accountability was the fact that for years and years and years and decades, the Baltimore Police Department wouldn't send cases over to the Civilian Review Board. And then even when the Civilian Review Board disagreed with its findings, it would not honor that. So that's why there was a need to do more, to expand the powers of civilian oversight, which in the consent decree that still exists over Baltimore Police, that consent decree created a community oversight task force. And one of the things that came out of the community oversight task force was this need to expand the civilian oversight of the Civilian Review Board. So I don't want to be long-winded, but I just want to be clear, because I don't agree, but I don't agree because honestly, there's no additional layer of investigation. There is not. If the 2 bills that we're talking about, the other one and this one, they wouldn't both become law. That would not be the case. So there would not be 2 different entities there would not be 3 different entities within the Equity and Civil Rights Office to do investigations.
So even if you took out one of those 2, that would still leave the Office of Attorney General, the Public Integrity Unit, the Administrative Charging Committee, or the Office of Equity of Civil Rights, or the Police Accountability Board. It would still be 4.
Like we can talk offline,
That's
but
fine.
that's not accurate. It's not. It's not.
Okay.
All right, seeing no other question, that ends the hearing on Senate Bill 763. We are going to next go to 764. That's you, Senator Carter.
Mr. Chair, members of the committee, this is a bill we've seen similar types of bills before. It's a Baltimore City only bill. City administration is here to testify. We've got Nina Themelis, Liam Davis, and James Turner. It's a bill that's been around for a long time, and it's another bill that would take into account a person's profession in determining what in expanding criminal penalties for committing an act of assault on them. And so with that, I'll let you hear from the city administration.
Good afternoon, members of the committee. Thank you for allowing us the opportunity to speak on this important piece of legislation. My name is Liam Davis, Legislative Manager for Baltimore City Department of Transportation, speaking on behalf of Baltimore City Administration. So what is Senate Bill 764? Well, this is a fairly simple piece of legislation that looks to afford our traffic enforcement officers in Baltimore City the same protections that exist for first responders in our police departments, fire departments, and in our correctional facilities. What do TEOs do? So our traffic enforcement officers provide a critical service to Baltimore City. They're the people out there enforcing parking regulations such as scofflaw, peak hour parking, residential permit parking, stadium event parking, and metered parking. They're also the individuals when you go to a sporting event or a special event downtown, they're helping assist with people crossing the road and directing traffic. Our TEOs are unarmed and they're providing this critical service to Baltimoreans every day. Staffing wise, our TEOs operate within the city's Department of Transportation Safety Division. There's roughly 90 TEOs currently operational, the majority of which are African-American women. Over the past several years, BCDOT has observed a rolling average of over 6 assaults a year happening to our TEOs. And a lot of times the incidents are actually happening at these special events, these stadium events, and in our nightlife districts such as Fells Point, Federal Hill, and Canton. The assaults have had a demoralizing impact on our staff morale and has actually made it harder for our TEOs to effectively enforce the critical laws to keep our roads clear and safe. With this in mind, I am asking on behalf of Baltimore City Administration that you support the passage of Senate Bill 764, and I am available for any questions. Thank you.
Good afternoon, Chair, members of the committee. I'll be speaking on behalf of Tavon Braxton today. I think he signed up to be online. Within Tavon's portfolio, he oversees the safety division wherein lies the brave men and women that have prompted this bill for your consideration. In summary of documented assaults to our enforcement officers that include incidents that describes accounts of male strikes several times in the face after getting a ticket, spit on by a citizen, struck by unknown object in the face, 2 males pull a gun on an officer. Those are just a few assaults, to name a few. Note that many of the officers were women and the outcome is often no prosecution or arrest, yet the officer is hospitalized. If you recall, in the earlier statement I made, I mentioned a summary of documented assaults. Undocumented assaults are not forgotten. The irony is that many of the officers have formed a soldier-like resistance born out of necessity due to the challenges in the field. Their first inclination is to defend rather than report. As a result, many incidents are unreported. By and large, our officers enjoy the work that they do. Many have made careers out of being TEOs. Others left due to hazards. And with fluctuating hiring and attrition, the looming dangers of the job exacerbate the challenges of staffing this workforce. What we can say with certainty is the demand for parking and directional traffic enforcement will remain high, and this bill will lend our officers to have peace of mind, knowing that TEOs garner the same amount of respect as other first responders, and would-be offenders will think twice before assaulting an officer. Knowing that a felony assault is subject to imprisonment and a fine, even if it's a $52 ticket that they're writing. The public will only grant the level of respect the leadership affords its representatives. Our officers are indeed officers, and they warrant a level of respect in accordance to the duty that has been placed upon them. Thank you.
All right. Questions from the committee? All right, seeing none, thank you all very much. Thank you. Good, one, Tavon is not in. Okay. So with that, that'll conclude the testimony and the hearing for Senate Bill 764. We'll now move on to Senator Carter with Senate Bill 850. Senator Carter, you're up.
Thank you. Mr. Chairman and members of the committee, I am waiting for one more of my panel who's in the hallway. Mr. James Wells, someone's going out to retrieve him. So I'll start though, if it's okay. So I think in hearing this bill, if you come to this bill with an open mind and without any preconceived biases about what the implications might be or the motivation for the bill, I'd ask you to start with asking yourself this question. Should a person be found guilty of first-degree murder when another person commits the act that causes the death, even if accidentally? And then if you ask that question, ask, should a young person, a teenager or a child, be found guilty of first-degree murder when another person commits the act that causes the death, even if accidentally? If your answer is no, then this bill seeks to address that. This bill addresses the issue of guilt by association. This is called the Accountability Act for a reason. It would seek to hold persons accountability for the actual act, crime that they commit, and not the additional crime of first-degree murder if a death occurs in the course of or commission of the underlying crime. This bill is something that I had a situation, or I know of a case in Baltimore County from just about 2 years ago, and I've talked about it a couple other times, where this is exactly what happened. So a marijuana transaction occurs. The potential seller of the marijuana is accosted by the potential buyer of the marijuana, who comes at the seller of the marijuana with a gun. The actual seller of the marijuana does not have a gun, but another bystander, a co-defendant, shoots the buyer and the buyer dies. There was no potential defense of self-defense because with felony murder, that's not an option. It's a strict liability offense, felony murder. And so in the situation like that, you know, there are some that could say, we don't care who did what. If you're committing any kind of a bad act, then hey, if a murder occurs, you should take that responsibility. But that defies reason and also actual accountability for the offenses. So if you ask, why does this bill limit to certain age, under a certain age, felony murder? I mean, I think I've come before with generally getting rid of felony murder altogether because I don't think it's an honest charge. And I think that when you limit defenses just because of its strict liability, I don't think it has any place in our code. But the reason is we know from research, and if we trust science, we know that young people are different. We know that young people have lesser ability to foresee and appreciate risk and future consequences of their conduct. We know that they have less impulse control, and we know that they are more impressionable and subject to peer influence and pressure than older adults. Thus, in the wisdom of different persons interested in this issue, we decided to limit the bill by age. But I think that it's something that we should really take a look at and consider across the board. As mentioned before, young minds often cannot and do not grasp potential consequences of their conduct because their brains are still developing. Accordingly, opposing life sentences on children and emerging adults fails to deter them and their peers from engaging in risky behavior and fails to adequately punish a young defendant because a life sentence under the circumstances is much too harsh. While this bill does not have a retroactive component, a prospective repeal of felony murder for juveniles and emerging adults would prevent the injustice of individuals serving many decades in prison for murders they did not actually commit. This will not sacrifice public safety in any way, nor will it prevent the state from holding these individuals accountable for the actual felonies that they committed or participated in. In sum, this bill will move Maryland closer to proportionality in sentencing, and for these reasons, I'd urge a favorable report. Thank you. Oh, you can go.
Good afternoon, Chairman Smith and members of the committee. My name is Rachel Kamens, and I'm an Assistant Public Defender in the Appellate Division. We're asking for a favorable report on Senate Bill 850, which prospectively eliminates the crime of felony murder for those under the age of 25. As Senator Carter said, felony murder is guilt by association. Felony murder is strict liability. Felony murder means going to prison for the rest of your life for a murder that you did not commit, did not assist, did not plan, and did not even consider might happen. How can that be? That's because felony murder allows prosecutors to charge and convict people with first-degree murder, which carries a mandatory life sentence, simply because they were participating in a felony, which is typically robbery or burglary, and someone winds up being killed. The theory underlying the felony murder doctrine is that a killing that occurs during a felony is foreseeable by all of those involved in the felony. But as applied to juveniles and emerging adults, the population we know is most vulnerable to peer pressure and the least likely to be able to assess the risks and consequences of their actions. Felony murder makes no sense and is profoundly unjust. This bill would put an end to charging youth under this guilt by association system. The bill would not result in the release of anybody already convicted of felony murder, and it would not prevent the charging and conviction of persons under 25 for first-degree premeditated murder, or second-degree murder, or conspiracy to commit murder, or as accomplices to murder, as long as the state proves intent. Intent is something the state does not have to prove when we're talking about felony murder. This cohort can also be charged with the underlying felony and the weapons offenses, both carrying decades in prison. Let's punish children and emerging adults for the crimes they actually commit. It's really that simple. Please give Senate Bill 850 a favorable report. Thank you.
Good afternoon, Chairman Smith, members of the committee. My name is Lila Meadows, and I'm a faculty member with the clinical law program at the University of Maryland, where I represent clients who are serving long sentences. And I'm here today to urge a favorable report on Senate Bill 850. Because felony murder is charged under the same statute as premeditated first-degree murder, which both the sponsor and Ms. Kamens alluded to, we can't offer you concrete numbers here. We can't tell you the number of individuals who are charged under a theory of felony murder each year. We can't tell you the number of people, let alone young people or juveniles, who are serving life sentences because of a conviction under this theory. But I think the numbers from other states are instructive here. Our neighbor to the north, Pennsylvania, found that 80% of people serving life sentences for felony murder were people of color. Of that 80%, 70% were Black. In California, a study found that among women serving life sentences for felony murder, 72% were not the principals in the killing, and almost all of them had experienced domestic violence in connection with that underlying offense at the hands of their co-defendant. And again, while I can't tell you what those statistics are in Maryland, I can tell you those statistics mirror what we see in the clinical law program when we represent clients who have been convicted of felony murder. And I spoke about two of those cases in my written testimony, including Arena Pretty, who served 42 years for felony murder in a robbery murder that her boyfriend actually committed the murder. Miss Pretty wasn't even present at the time that her boyfriend shot the store clerk. The General Assembly has already recognized that Maryland must address extreme sentencing of youth by passing the Juvenile Restoration Act in 2021. That measure was a critical step towards back-end reform, and I'm grateful that I have that mechanism for release for my clients. But it's not retroactive. And for that reason, I would ask this committee to start thinking about the front end of our mass incarceration epidemic in the state and issue a favorable report on Senate Bill 850.
Good afternoon. My name is James Wells Jr. And I think this bill should pass because in 1977, my co-defendant and I were robbing a jewelry store. We were detected inside. We got hostages. We came outside and commandeered a police car. They shot the police car up. There was another one right behind it. We got in that one, and we left off the lot. We were trying to get somewhere where woods so we can escape. Anyway, we in a way going to in town. We took another car, and from that car, there was a roadblock set up on Security and Ingleside Avenue. And when we got there, really we couldn't go nowhere, but they started shooting, so we tried to go through the roadblock. An off-duty police officer fired a fatal shot that stopped the car. Once the car was stopped, my co-defendant, who was in the front seat, pulled the jeweler who was up front with him. And when he was getting out the car, he got shot 3 times, so he went to the ground. But the officer that was behind him, he was off duty. And anyway, he fired the fatal shot as shooting at my co-defendant, and he shot the jeweler in his neck and killed him. We were charged with felony murder. This happened in 1977. I served 43 years, 2 months, and 10 days. I hope that this bill pass because we never fired a shot. I met with the victim's family, who was awarded $2.5 million in 2004. I apologize for my former behavior. In 2019, they came to my 11th parole hearing and asked the parole board to release me. So I got released July the 10th, 2020. I've been home 3 years, July the 10th.
All right, thank you very much. Questions from the committee? This is a quick question for either the sponsor or Ms. Meadows. So would this touch the second degree murder, like felony murder for second degree murder? It seems like it doesn't. Can I read you the instruction, the jury instruction for second degree murder, felony murder? It seems like it wouldn't. Does this bill touch that? Does this bill affect that at all? Is the first question, and then.
I don't think so.
Okay.
No, it's not. I don't think so.
Okay. So I'm reading the jury instruction. It says a person may be guilty of second degree murder if there was a killing in the commission or attempted commission of certain felonies. The defendant has been charged with the responsibility for the death occurring in the commission of insert felony, yada, 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 it goes on. So this doesn't touch that. Is that a reform you're also looking to, or just trying to understand?
I think that when I've met with different advocates, they've focused on first degree because that is the most common offense. First degree felony murder, second degree felony murder happens, but it happens very, very rarely. It happens actually in a situation like I described with marijuana not being sale, not being the same level of felony as the first degree felony, like armed robbery. So the situation I talked about in Baltimore County was a second degree murder, felony murder, because it was a marijuana sale, as opposed to like an armed robbery, if that makes any sense.
That makes sense. Thanks. I just wanted to know if that's bill touches that. All right. Questions from the committee? Seeing no further questions, thank you all very much. Thank you. All right. Thanks, man. Is Steve Atah? Is Elizabeth Lowe? Stephen Gravitt? And Mr. Four, Christine?
Good afternoon, Chairman Smith and members of the Judicial Proceedings Committee. My name is Elizabeth Lowe, and I'm a student attorney in the Youth Education and Justice Clinic at the University of Maryland School of Law. The clinic represents individuals serving life sentences for crimes that they committed as children or emerging adults. Maryland's felony murder law runs counter to the science on adolescent brain development. The prefrontal cortex is the portion of the brain that guides our ability to contemplate our short-term and long-term consequences of our actions. Science has proven that the prefrontal cortex does not fully develop until an individual reaches 25. Maryland's felony murder law ignores the brain science, in part because it rests on foreseeability, holding individuals accountable for any foreseeable death that occurs during a commission of a felony. However, the brain science shows that children and emerging adults are less able than older adults to foresee these consequences. Importantly, the U.S. Supreme Court over the past 17 years has relied on brain science to outlaw or limit the imposition of the harshest sentences for children. Citing the brain science, the court has reasoned that children are less culpable and more likely to rehabilitate. The same exact brain science applies equally to emerging adults. Further, SB 850 is necessary to help redress Maryland's racially disproportionate incarcerated population. Nearly 80% of individuals who have served at least 10 years in Maryland's prisons are Black. Data from several other states reveal that Black individuals are disproportionately represented among those who are convicted of felony murder. SB 850 is a significant step towards aligning law with brain science and alleviating the racial disparities that plague Maryland's incarcerated population. For these reasons, I ask for a favorable report.
Hello, my name is Steve Gravatt, and I am here to provide a juror's perspective on the felony murder rule. In 2020, I was alternate juror number 1 for a federal trial where the defendant was charged with armed robbery and felony murder in the first degree. The defendant participated in a robbery where his accomplice accidentally killed the victim with a box cutter. As a juror, I was torn between competing duties. On the one hand, I wanted to do the right thing, and condemning a non-murderer to a murder one sentence did not seem like the right thing to do. On the other hand, I wanted to do my civic duty and apply the laws of the state as best I understood them. Since I had no reasonable doubt that the defendant had participated in a premeditated robbery or that the robbery had resulted in a death, that meant finding him guilty of first-degree murder. Whatever choice I made, I was going to feel bad about it. Fortunately for me, all of the real jurors made it to the end of the trial, so I didn't have to participate in rendering a verdict. I later learned that the jury found the defendant guilty of armed robbery, but innocent of first-degree murder. There are 2 possible explanations for this illogical finding. The first is that the jury simply didn't understand the law. After all, it's counterintuitive that the state would expect you to find a non-murderer guilty of murder. The other possible explanation is that the jurors willfully chose to disregard the law because they found it unjust. The crux of my testimony is that the state of Maryland should not be asking its citizen jurors to enforce a law that is either so illogical we are liable to misunderstand it, or so contrary to our sense of justice that we choose to disregard it. So long as the felony murder rule remains on the books, it's important that we reduce the charges associated with it. By removing the first-degree murder charge for Marylanders under 25 convicted of felony murder, we will reduce the burden on jurors to condemn young people who haven't murdered anyone to a lifetime in prison. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Christine Dufour. I'm with the law firm Jezik & Moyes, and I'm here on behalf of the Maryland Criminal Defense Attorneys Association. And on behalf of our association, which includes close to 500 attorneys across the state and every county, we respectfully urge a favorable report. And we thank Senator Carter for bringing this. I would basically say that I would echo the testimony of Rachel Kamens, my former colleague at the Appellate Division of the Public Defender's Office. I think she laid out an excellent argument as to why this bill should be passed, and we'd respectfully request that this committee 850. Thank you.
Good afternoon, committee. My name is Stephen Atta, and I am Associate Director of Res Life. I And I'm here to testify against Bill 850, the Youth Accountability and Safety Act. Oh, I'm sorry, in favor of. I just want to start real quickly to kind of echo Senator Carter's earlier testimony. My brother was he was doing a sell for marijuana. He was selling marijuana and he was attacked by 10 men. He had an unlicensed carry for a gun. And unfortunately, he was booked. He didn't kill nobody. He didn't take no one's life. And he didn't take a life himself. And he impacted nobody but himself. Unfortunately, he's spending life in prison currently for wrongful actions and was booked at the age of 21. So today, I'll stand up here today to have a voice for the voiceless, to testify for my brother who, who did everything he can to make sure that my mother who had 3 jobs, couldn't take care of any kids at home. So he decided to be the man and kind of unfortunately, went down a dark path to make ends meet. And I'm in favor for this bill because I believe that he deserves a second chance. And the reason why I do what I do today is to make sure other Black men in the communities, unfortunately, don't slip, because I'm afraid that we don't give second chances to a lot of people. And it's unfortunate because I know I sit here today in front of all you guys, and I wish and I hope that you guys get second chances, and whether that's in life, marriages, with your kids, and so on and so forth. So I'm in favor today for this bill, and I pray that you guys have forgiveness and ask for forgiveness for those less fortunate and less in these communities. And thank you for your time.
Excellent. Thank you very much for your testimony. Questions from the committee? All right, seeing none. Thank you all very much. Thank you for taking the time today. Is Lindsay Heminger here? And then we've got Emily Virgin and Heather Warnken.
Good afternoon, Mr. Chair and members. My name is Emily Virgin, and I serve as the Director of Advocacy and Government Relations at Human Rights for Kids. I also have the honor of serving my home state of Oklahoma in the State House there, so I want to thank you for your service to the great state of Maryland. Human Rights for Kids is a DC-based nonprofit focused on the protection and promotion of the rights of children in the criminal legal system. In 2020, because of the way children were treated in the system in Maryland, we designated the state as one of the worst human rights offenders in the nation in our state ratings report. Maryland was penalized in part for its application of the felony murder doctrine to children. While it's very important to note that because of the work that this committee has done, that vital reforms have passed and they've affected children in the legal system, and therefore in our 2022 report, we recognized Maryland as the most improved state. But Maryland is still penalized for its felony murder policy. In contrast, 3 states have completely abolished their felony murder statutes, and 10 more have affirmative defenses for either children or all defendants charged with felony murder. We support this bill because the application of the felony murder rule to children runs counter to international human rights standards that require states to avoid sentencing children by the same standards as adults and to consider child brain and behavioral development science when charging and sentencing child offenders. We know, and you've heard many times, that because of their underdeveloped brains and diminished capacity for decision-making, children often fail to appreciate the unintended consequences of their actions. And nowhere is this more apparent than in felony murder cases where children can be criminally convicted of first-degree murder, even though they did not kill or intend to kill anyone during the commission of a felony offense. It's for these reasons that we ask for a favorable report on Senate Bill 850. Thank you.
Good afternoon, Chairman Smith, members of the committee. My name is Lindsay Heminger, and I'm a student attorney in the Gender Violence Clinic at the University of Maryland Carey School of Law. The clinic has represented numerous clients serving life sentences for felony murder convictions they received before the age of 25. They're serving life sentences for murders they did not foresee, they did not intend, and did not actually commit. They're serving longer sentences than individuals who actually did commit a murder, because second-degree murder, which is an intentional killing, carries a maximum sentence of 40 years. A felony murder conviction results in a life sentence. As others have mentioned, the brain science in children and emerging adults indicates the felony murder doctrine is not workable for young people. By allowing prosecutors to use the felony murder doctrine to convict juveniles and young adults for murders they didn't commit, we are accepting the premise that these young people are irredeemable and deserve to die in prison, because the reality is that many of them will die in prison. Our clients are often not eligible for relief under the Juvenile Restoration Act because they were not under the age of 18 at the time that they committed time that they were convicted. And minors convicted of felony murder after October 1st of 2021 do not have the benefit of relief under the JRA. Our client's only option for relief is through parole, which is rarely granted the first, second, third, or even a dozen times that they've gone before the parole commission, if they're even granted parole at all. It's time for Maryland to end charging young people for murders they did not actually commit and require prosecutors to meet their burden of proving the elements of murder before we send these young people to prison for the rest of their lives. I urge a favorable report on Senate Bill 850. Thank you.
Good afternoon, members of the committee. My name is Heather Warnken, and I am the Executive Director of the University of Baltimore School of Law Center for Criminal Justice Reform, here in strong support of Senate Bill 850. From a public safety standpoint, the felony murder rule is simply not effective in reducing violence or advancing accountability for perpetrators of harm when violence does occur. The literature demonstrates that lengthy prison sentences are not effective in achieving deterrence, but perhaps even more relevant for this bill is the research specifically demonstrating that individuals are not deterred by punishment they are not aware of. Knowledge of the existence of this antiquated rule is extremely limited, and even for individuals who may be aware, it does not serve to deter behavior that a defendant had no intent of engaging in or could not expect to occur. The existing felony murder law is a draconian practice which serves to delegitimize our criminal justice system. This system is already suffering a crisis of legitimacy in the eyes of many Marylanders. It is a system purporting to be about fairness, where the punishment should fit the crime, yet where well-documented racial and socioeconomic disparities already play an outsized role in determining outcomes at nearly every step. Given the ways that felony murder undermines principles of justice and fairness, it has been abolished by every other developed nation on earth besides the United States. A growing number of states, as we've heard, have also ended felony murder, including Ohio, Hawaii, Kentucky, Michigan, and Massachusetts, while other states have limited its broad application, including Arkansas, New York, New Jersey, California, Connecticut, Delaware, Maine, North Dakota, Oregon, and Washington. Maryland can take an important step forward in enacting this modest but much needed reform. We urge a favorable report. Thank you.
Question for Ms. Is it Virgin? You said that there were some states that had abandoned felony murder. I was looking through your testimony and I didn't see which states they were. Would you mind sharing?
Yes, and I think one of my fellow panelists may want to chime in on that as well. But we have 3 states that have completely abolished or perhaps never had the felony murder rule. And those are California, Hawaii, and Kentucky. And then several more do have statutes. Some of them are specific to children that provide for an affirmative defense to a felony murder charge for a child. And then some of those apply an affirmative defense for all defendants.
And what's the affirmative defense for the children?
So one example would be Arkansas. And they have a statute that says specifically for children, if they're charged with felony murder, but they can prove that they had no intent, then that is an affirmative defense to the charge.
Thank you very much.
Thank you, Mr. Chairman. This question is for Ms. Heminger. You better go up to the podium there so they can catch you on camera. So you're with the University of Maryland Law School in some capacity. What do you do there?
I'm a student attorney in the clinical law program. We've had some other panelists who've also spoken, but I'm practicing under the license of my professor who runs the clinic.
Okay. And how old are you?
26.
26, but you're still in law school.
Yes, I'm a 3L.
So when I was in law school, I was between the ages of 22 and 24. I just turned 25 shortly before I graduated. Would you say many law students are between the ages of 22 and 25?
I think at the University of Maryland, there's a wide range. We have plenty of students who are in their 30s, but there are, of course, students who went right through undergrad to law school.
Like me, right. So now I'm going to quote the sentence from the testimony of the sponsor of the bill. She said, young minds often cannot and do not grasp the potential consequences of their conduct because their brains are still developing. In your experience, are the students at the University of Maryland Law School between the ages of 22 and 24 incapable of grasping potential consequences of their conduct because their brains are still developing?
I would separate the individuals who are attending law school from the individuals that we represent at the clinic who are maybe growing up in neighborhoods that they do not have the privilege of quality education and are not people who are going to end up in law school. The people that we represent are people who have been through significant trauma, who are living in poverty, and their life experience is very different than many of the students who I go to school with. So I think that while of course, law students' brains are still developing because that is just the science. I don't think that we can equate the people who would be affected by this bill necessarily with people who are attending law school.
So if we were to pass this bill, would you think it appropriate for us to divide the human population of people between the ages of 22 and 25 into two groups? One that goes to the University of Maryland Law School, whose brains are developed, and the other is everybody else whose brains just aren't developed as well as law students. Is that correct?
No, I think the brain science in young people's developing brains applies to everyone. I don't think that we should treat them differently. If somebody who was attending law school had committed a crime and a murder had resulted, I do not think that they should be held responsible for that murder either, because really what the felony murder bill does or doctrine does is it tries to hold people accountable for something that they didn't actually do. And so I think that anybody under the age of 25 should be treated exactly the same.
So in your view, the students at the University of Maryland Law School should be found to not be able to grasp the potential consequences of their conduct and therefore be let off the hook if they were involved in a felony murder, correct?
Well, I want to be clear that people would not be let off the hook at all. There's plenty of laws for people who are found to be accomplices to murder, who conspired to murder, and they will be held accountable for the underlying felony for which they actually did commit. So no one is being let off the hook here. People are simply just being held responsible for the crime that they actually did commit.
Thank you for your testimony.
Thank you, Mr. Chairman. I just have a quick question, and Professor, you may be the one to answer it. But on the limited application on those 10 states that you discussed, are any of those, or are they doing a similar design framework of 25 and under, or is this something that we're spearheading here in Maryland? Do you know offhand? I'm sorry. Whoever.
I don't know the specifics. I do think there's quite a range in the ways that politically and geographically diverse mix of states that have limited felony murder have approached it. And I would just say before I turn it over to my co-panelist here, who does have some of those specifics, that our center would be happy to provide copies of those statutes if that would be helpful.
Yeah, that would be great. I mean, I'm genuinely, I'm asking because I don't have the answer. I thought maybe someone up there might, but the 25-year age is kind of stands out to me because we send troops overseas to die for our country at 18. Now, there is some methodology behind that they still are very much moldable and into soldiers that they need to carry out these duties. So I understand that part of the science as well. I'm just curious about the 25 number where that kind of originated from.
Well, I think well beyond just the area of felony murder, there has been quite a trend across laws throughout the country based on the brain science, as my co-panelist, I think, so competently and eloquently just spoke to. So yeah. I think that no, Maryland would not be unique in using this framework based on the evidence that we have.
Okay, thank you.
Senator, I can tell you that through my perusal of the states that limit in some form or fashion, I don't see those that differentiate on under 25, but there are states such as Washington that provide an affirmative defense to everyone. So they would apply that to any adult defendant as well as a juvenile.
Gotcha.
Yeah.
Is there any other state that you know of that does even like a 21, or do they just leave it as the standard 18 with the understanding that we're crafting language to kind of,
I think,
I guess, remove?
If I'm incorrect, and I will do some digging after this and follow up with you, but I don't think that there are states that limit based on something above the age of 18. But like I said, 3 states have abolished the rule completely for everyone, and then those others provide some sort of affirmative.
I'm sorry, maybe I misspoke. I wanted to make sure that, you know, the 25 just seems like an arbitrary number. I'm sorry. I know it's with the brain science. I understand that part. But otherwise, as far as calling it, you know, a Youth Accountability and Safety Act, I mean, 25, you're not a youth. I mean, you're not. 18. So I'm just curious again, and you guys can get this to me. I'm just really genuinely asking, are there any other states that have even implemented a 21-year-old age, or have they always just stuck by 18 as being an adult, and then the measures moved forward from there with the felony murder rule applying regardless at that time?
Based on my quick perusal of all of our data on other states, I don't see anything that is different from the demarcation of 18 and
okay.
above.
All right, that's fair. Thank you. I appreciate it. And Professor, if you do find any of that stuff, I'd appreciate it. Thank you very much. Thank you, Mr. Chair.
That discussion just made me wonder, is there any science behind 18? I mean, because to me, it seems 18 is just cultural. Is that correct?
That is absolutely correct. There's nothing magic about the age of 18. And what, you know, you've heard many times is that the brain science tells us that it's actually 25 when brains are fully developed. So I would have to do a lot of research to figure out where 18 came from, but it seems pretty arbitrary.
Don't worry about it. It seems cultural to me. Thank you.
Let's go with 40. I feel pretty youthful, and I'm definitely still developing. At least that's what my wife says. Yeah. All right, Senator Carter, go ahead.
Thank you very much, Mr. Chair. Me too. I often say that when I think about these bills, I think I was in my 40s before I finally matured. Luckily, I didn't commit crimes or get caught with any, but certainly I did a lot of stupid things. I'm thankful, very thankful that I wasn't always held to account to the maximum extent for the stupid things. I think I want to ask the same question because I want to do a follow-up. Unfortunately, Senator West has left the room, but I remember when I was a law clerk to a circuit court judge in Baltimore City, right after law school, and this was the 90s. But one of the things that struck me was that my judge kept an account of every individual that came before him in felony arraignment court. And consistently, this was the profile. 8th grade education level, and this was the 90s, so it could be lower than that by now. Some type of developmental disability, often exposure to lead poison, or some type of drug addiction, or drug dependency. And there was something else. There was some, just, and we know that, inadequate education system, but regardless, so that I just wanted to highlight that was in the 90s, the profile of the average person that came before the circuit court in Baltimore City and felony arraignment court, highly different than, I would say, the average. Not that persons like that don't make it to law school, because it happens with those backgrounds, but highly different than the background of someone such as, say, myself, that actually, had none of those issues, not one single one of them. And so actually, I just wanted to highlight that issue. It's not really a question. And then, Mr. Chairman, would you give me the latitude to ask Mr. Wells a question, if he's still here? I can't tell if he's here because the podium's in the way, if he's still in the room. Mr. Wells? I don't want to put you on the spot, but I'm super stoked that you're here. I first communicated with Mr. Wells when he was behind bars, and I didn't know it, but when he came out, I met him and he talked to me about our communication. And I asked him to come here for this bill. And I want to make sure everybody heard his testimony. I'm not sure how old he was at the time, but basically, his testimony was that he was in the act with others of committing an armed robbery, and that in the effort to get away, the law enforcement officer shot and killed the victim, and yet they were charged and convicted of felony murder and served 43 years. And so you came here to testify because you agree that felony murder is too harsh a sentence for the underlying felony that you committed. Is that correct?
Yes.
So I want to kind of hear from you, because you talked about your experience and what happened to you. You had 43 years in prison. If you can speak about this, and not long, but if you can speak about it, why is this a good idea to prevent what happened to you from happening to other young men and women?
Well, overall, there were over 500 shots fired into the 3 cars. And the victims, the jeweler's wife, sued. And the case was sealed. I didn't get the case till 23 years later to come to find out the people at the roadblock didn't even know hostages was in the car. They didn't, by the time they asked them what hostages in the car, that was 500 shots later. So this was something that we got like 23 years later. Now, I agree I should have went to prison because I was taking something that didn't belong to me. But for 43 years, 2 months and 10 days, no, I don't agree with that.
No.
You're welcome.
Thank you very much. All right, seeing no further questions, thank you all for being here. Thank you. Special shout out to the University of Maryland Law School. All right. Is Jahan Manaki here? Do we call Margaret Berry? There you go, Miss Berry. Called Heather. Is Gabrielle Bradley and James Wells. James already went, that's right. Whoever would like to go first. Just the 2 of you. All right, one more. Yeah.
Good afternoon and hello. My name is Gabrielle Bradley, and I traveled today from Pennsylvania to testify in support of Senate Bill 850. I am also the wife of a wonderful man who I have been with for 18 years, and of that 18 years, he has served 16 of a life sentence in prison for felony murder. Although he was found not guilty of committing the actual murder and was found not guilty of the sole underlying felony that could constitute a felony murder conviction. I support this bill because I feel like for far too long, young men and women, especially young Black men, have been disproportionately sentenced for a crime of murder that they did not commit. I kind of want to speak briefly about an article I read in the Maryland Daily Record titled "It's Time to Abolish Felony Murder in Maryland." It spoke about a 20-year-old young man who was at a party and learned that his friends wanted to rob a local drug dealer. So he lent his car keys to his friends and then went to sleep. During this robbery, someone accidentally died. This young man was not charged with an accessory to a robbery, but he was charged with felony murder and is now serving a life sentence in prison. I feel like prosecutors have enough tools under their belt to charge accordingly, and I feel like to get a substantial amount of prison time out of a person who commits a violent crime. But I don't think that charging somebody or convicting somebody for a murder that they did not commit is just. I fully believe that one should be held accountable for their actions for sure, and especially if they commit a crime of violence. But to condemn someone to a life sentence in prison, and in the most worst case, without the possibility of parole, when knowingly they did not kill anyone, is just unjust and unfair. So I urge a favorable report on Senate Bill 850. Thank you so much for your time.
Good afternoon, everyone. I'm Margaret Martin Barry. I'm an emeritus professor of law. I'm here today on behalf of the Montgomery County Women's Democratic Club in support of SB 850. Felony murder has been called, among other things, and it's called this by the Model Penal Code and its commentaries, an indefensible principle. Others have been less kind. One scholar called it an unsightly wart on the skin of criminal law. There have been others who've gone on, but the idea is that it really is a failure in our criminal system. Why? Because we impose the most extreme level, as you've heard today, the most extreme level of culpability, and we do away with two fundamental aspects of our criminal law, causation and intent. The main theory for chucking causation and intent when it comes to felony murder is deterrence. But how do you deter an unintended act? We turn to then, well, but they should have foreseen in the course of doing certain felonies that this terrible thing would happen. And that attribution might go to recklessness if you want to go that far, but it certainly doesn't go to premeditated murder, which is what we have under Murder 1. There's no premeditation here. There's no even causation here when you bring in felony murder, because under this theory, you don't need to prove either of those. The arabesque of the felony murder rule is most problematic when it's applied to children and young adults. And the question came up earlier today, where do we get this idea of emerging adults? And emerging adults, as the law student from University of Maryland pointed out, is supported by the brain science. In terms of, has it been used before? If you look to our neighboring jurisdiction, the District of Columbia, could I just respond on that one?
No, we're not up to questions. If you could just conclude your remarks.
I'll address it then later. Thank you. We do urge a favorable report of this bill.
Thank you.
Thank you.
Good afternoon. Hello, my name is Jahan Manoki, and I support Senate Bill 850. The guilty by association rule, better known as felony murder, is a statute that should be abolished in Maryland. The law is unjust and unconstitutional. The law allows for individuals who are not the principal in the crime to be charged, convicted, and sentenced to life in prison for a crime that they did not commit. In some cases, people are sitting in prison with a life sentence and they were not even at the scene of the crime. I truly believe that people should be punished for the crimes that they commit, not the crimes that they didn't commit. Imagine if it was you. Imagine if you were sitting in the car. Somebody says, just let me go into this grocery store. And they try to rob them, and suddenly you're in jail and you're charged with a murder. You didn't do anything. How would you feel about it if it was you? Think about all the money that has been lost and all the families that have been disrupted because innocent people went to jail. Imagine going up for parole, and the first thing that the parole wants to see is you take accountability for the charge that you were convicted of, and you know you didn't commit that crime. All of this is because something that is called guilt by association, the felony murder rule. This is the power of the felony murder law. If we have this going on, then every stockholder in every company that rips people off will be guilty, wouldn't they? I'm here today for my 3 sons, my daughter, my 2 grandkids. I want to make sure that we have a voice in this world and I can protect them. Thank you.
Thank you so much for your testimony here today. Questions for this panel, Senator West.
Thank you. Professor Berry, I'm going to give you your chance to finish your earlier thought, but I want to package that in the context of question. So what this bill seems to me is really about is whether we ought to have the underlying theory of felony murder. It really is, it should not be about whether someone between the ages of 18 and 24 is able to appreciate the consequences of a conduct. If we establish that, wouldn't you agree? We're opening up a huge Pandora's box, and there are going to be lots of bills in future years to let people between the ages of 18 and 24 off for things that they've done, claiming, oh, they couldn't appreciate the consequences of what they did. Isn't that a bad road to head down? Don't you agree?
Well, I don't think the Supreme Court's headed down that road, as you know, Senator. And I think that it's certainly good for us to take into account the level of culpability of a criminal that we're convicting. And that's where the brain science comes in. On the other hand, I fully agree with you. And I think even Senator Carter indicated that we should do away with felony murder altogether. This was a step in that direction.
Yeah, it seems to me that's something we could take a look at. Maybe should take a look at.
I wish you'd vote it right on out of
at
here.
an appropriate time, but the idea of tying this to the fact that somebody's 24 years old and can't figure out what the consequences of his or her actions are going to be, that's just crazy in my view. And I can't imagine that we're going to go down that road because again, it opens up the Pandora's box. We'll never get away from it. So now that I've gone through that, I assume your position is that felony murder should be abolished altogether.
Absolutely.
Okay. And should be abolished not only for people between the ages of 18 and 24, but for people older than that.
Yes, again, because I firmly believe that if you're going to convict someone of murder 1, you have to prove causation and premeditation. And that's done away with felony murder.
Okay. Thank you for your answers to my questions and
Certainly.
your honest answers to my questions. I appreciate it.
Senator Sidnor.
Thank you. No, I wanted to thank the professor for your explanation. I couldn't agree with you more. I think felony murder needs to go away. It's like a legal fiction of blaming blaming someone for a crime that they did not commit because they happened to be in the area or it somehow related to some other crime that may have occurred. And I think just from listening to you all, you're not saying that people should be held accountable for their own actions, correct?
No, I mean, if someone's involved in a robbery, for example, the fact that someone got killed during that robbery, but they didn't cause it, they're still going to be charged with robbery, and that carries a 15-year sentence. If it's with a deadly weapon, it's a 20-year sentence. I mean, these aren't light sentences. If you're going to be deterred, you're going to be deterred by those sentences.
Right. And I mean, because I look at my state's attorney's written testimony and where we had one of our officers killed murdered back in 2018 by someone, and a number of juveniles ended up being charged in that, and if you were to read the testimony, it's as if we don't have felony murder, we're not going to be able to hold everybody accountable. And that's just not the case. These other defendants, they would have likely been charged with other crimes, correct?
They would have, and they should have if they were involved in those crimes. What they
Correct.
shouldn't be charged with is the crime they didn't do.
Thank you very much.
Thank you, Senator Fulton.
Professor, hi, I just wanted to give you a chance to finish your statement. I'm sorry.
Oh, yes, I was just going to refer on the emerging adults analysis, that in the District of Columbia, when they passed their equivalent about Juvenile Restoration Act, Juvenile Restoration Act, they came back and amended that to include emerging adults, because they, again, looking at the brain science, the analysis was that it should go beyond the age of 18. So I just wanted to flag that precedent. It's not kind of pulled out of the air.
Yeah, no, I appreciate that. And I just wanted to make sure I got your full explanation, because I know you were
Thank
trying to
you.
squeeze it in on your own time, and it
Yes.
wasn't really fair. So thank you.
Thank you.
Appreciate it. Thank you.
Any further questions for this panel? All right, thank you so much for your testimony here today. For those of you who came from out of state, appreciate you coming a long way. We'll now move to the in-person unfavorable before moving back to the virtual. So State's Attorney Schellenberger, Billy Katziff, Stephen Kroll, you are up.
Good afternoon, Scott Schellenberger, State's Attorney for Baltimore County. I'm sure you all knew I'd be here. So 16, you can drive. Your brain works good enough to drive. 18, we've all decided your brain works good enough to vote and to go into the armed forces. 21, your brain works good enough. 21, your brain works good enough to drink. But at 24, 364 days, when you go into a liquor store with a co-defendant who's carrying a gun with the premeditated intent, that's where the premeditation comes from, to rob the place, and they shoot the liquor store owner and kill him, somehow your brain's not working. Does that make any sense to any of us? Let me tell you about one real case, not a hypothetical. On May 21st, 2018, Officer Amy Caprio was murdered. All 4 defendants involved in that case were charged with her death. They were all juveniles. But those 4 juveniles had set out that day to steal a car and to break into houses in Baltimore County. And they were planning so much that they didn't all 4 break into the houses. Only 3 would break into the houses, and 1 would remain in the car as the getaway driver. Behind the wheel, car running, ready for the other 3 to jump in the back seat, and they could take off. Well, unfortunately, citizens in the area were very concerned about this car, and so they called the police. And unfortunately, Officer Amy Caprio arrived on the scene. She saw 1 person in the car. She actually pulled her weapon and said, "Get out." And Dante Harris started to pretend to get out and then slammed the door shut, hit the accelerator, running over Officer Amy Caprio, killing her. I watched that body camera video. It very well may be the worst 30 minutes of my life before anybody got there to try and help her. The defendant who was driving, Dante Harris, killed Officer Amy Caprio. He was 16 years old. He killed her in cold blood. He was only in that car because the group planned to break into houses and have someone who could help them get away and get away fast. And because of that, we need to keep felony murder. Remember, it's a list of felonies that we consider to be inherently dangerous. Carjacking, rape, robbery, use of a handgun, breaking into someone's house. There's nothing more scary than when people break into someone's house. you ever come home and seen that your house has been broken into and the fear that you have? Dante Harris was convicted of felony murder. He received a life sentence. The place where you make the difference and make the adjustment is in the sentencing. The 3 co-defendants were all convicted of felony murder, and their sentence was 30 years. So you have the flexibility right now to adjust the sentence based upon the actions of each individual defendant. Harris, who drove the car, got life. The other 3 who were participants, they would not need a getaway driver if they weren't breaking into cars. So that's what we were talking about when we were mentioning premeditation. And when you talk about a deterrent effect, it's not the murder. I mean, you want to deter the murder, but you're trying to deter the felony so that nobody's breaking into houses and then somebody gets killed as a result. That's what the intent is to do it that way. And Mr. Wells's case, I'm very happy for Mr. Wells that he's doing well. But if you listen to what he said, they were committing a robbery. They kidnapped an innocent person. They ran their car towards police barricades. That's incredibly dangerous conduct. And what we say in our law in the state of Maryland is when you engage in that type of conduct, you need to be held responsible for all logical things that could happen. And that's what the felony murder doctrine is based upon. You've engaged in a dangerous felony, and therefore you need to be held responsible for everything that happened. I agree, Senator West, this picking of 25 for somehow at 24 years of age and 364 days, my brain doesn't work for felony murder, but the next day it will. It makes absolutely no sense. And we've been up here before, time and time again, talking about getting rid of felony murder totally. And we all, because of cases like this, come to the conclusion that we shouldn't. I urge an unfavorable report on Senate Bill 850. Thank you for the extra time.
Vice Chair, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland and Executive Director of the Maryland State's Attorneys Association. And I've been prosecuting cases since 1984. You know, Senator West, you could be 21, 22, 23, 24, and serve in this legislature and make important decisions about people's lives at that age. Not just law school students, but anybody could do that. I want to take this example and say the following. Are you going to prosecute this case? 5 bad police officers robbed someone. In the course of them robbing someone, one of the officers kills that person. The state's attorney at this point, or the attorney general, if they get the case, are they going to be limited if you pass this statute that they can't prosecute the other police officers who are part of the 4 others who didn't shoot but are there? They could get a felony murder charge against them. Pass this law, we can't prosecute those police officers for felony murder, for their responsibility. I'm suggesting to you that there are unintended and intended consequences to this bill. Police officers 21, 22, 23 years old, you're gonna say, no, you're not responsible. You can't do that because you're underage. Your brain hasn't been developed as a police officer, but you go and rob someone and kill them and you can't be held responsible. That's just plain wrong. And you're limiting us, meaning prosecutors, to go after bad police officers. I suggest to you we should not do that. Limiting the felony review statute, limiting it here creates bad intended and unintended consequences. I suggest a 21, 22, or 23-year-old, as Mr. Schellenberger said, could vote, can drink, and serve in this legislature, and they should be responsible for their conduct. That's why we should oppose the felony murder rule. And we'd ask for an unfavorable report as to Senate Bill 850, and I'm happy to answer any questions. Thank you.
Mr. Chairman, members of the committee, my name is William Katzoff. I'm an assistant state's attorney from Anne Arundel County here on behalf of the Maryland State's Attorneys Association, and I too am speaking in opposition to Senate Bill 850. A violent felony committed with a firearm is a homicide waiting to happen. Someone that participates in a robbery, participates in a carjacking, and there's a firearm involved, there's participating in an event in which that is highly foreseeable that someone will die. Now let's get to the bill. Now, this particular bill would say that if there was a carjacking that occurs tonight, okay, two people are involved. Okay, one of them was born on March 1st, 1998. The other was born on March 20th, 1998. One is 25, the other is 24. That means that one could be convicted of felony murder, the one who has reached the age of 25, but the one who is a few days short of his 25th birthday cannot. Let's take a situation where you have a 24-year-old who's very smart, very streetwise, very cunning, has quite a substantial record. One of his friends happens to be someone who is 25 years old, is a novice when it comes to the criminal justice system, has no record. It's decided that they're going to participate in an armed robbery. The 24-year-old gives the 25-year-old, a very unsophisticated 25-year-old, a gun. In the course of and it was not intended that somebody would die, but in the course of the robbery, the 25-year-old got a little bit nervous and fired a shot and killed the proprietor of the store that was where the robbery took place. That 24-year-old who gave him the gun to participate in a robbery, that person cannot be convicted of felony murder. That doesn't make any sense. Of course, he should be convicted of felony murder. And let's take a situation where I have two people involved in a robbery, someone is killed. Now, we just don't know exactly which one actually fired the kill shot. Well, we know that they were together, and as they walk out of the store, it's ultimately determined based maybe on because of the car and the license plate who the persons were. Each is arrested, each points their finger at the other, accusing them of being the shooter. How am I going to prove who actually fired the shot? And without that, you can't have a felony murder with the 24-year-old. How can I prove who fired the shot in that situation? Ladies and gentlemen, this bill should be voted down. I strongly urge an unfavorable report.
Thank you all for your testimony. Fun fact, Ben Pardon was 23 when he was elected to this legislature. Senator Carter has a question.
Certainly. So I just want to reiterate a couple of things. And Mr. Schellenberger, it may not surprise you that I really, not only do I disagree with you, I'm a little astounded that even you in this day and age would posit that a sentence, negotiating a sentence is somehow analogous or somehow the equivalent of how a charge is made. Meaning, we talked about this, like a first degree felony, you can get 20 years for it. If those young people that were nowhere near Officer Caprio when she was hit by the car committed multiple armed robberies, if they did, the sentence for each one could be 20 years, correct?
That is correct. In this case, they were committing burglaries. They weren't committing robberies. And the whole concept behind felony murder is that but for them breaking into houses and needing a getaway driver, Officer Caprio wouldn't have been killed by Dante Harris. And my point was, and I certainly understand and respect your point, and that is, make the adjustment on the crime, not on the sentence. But in my opinion, the adjustment in this case was on the sentence, and that's where it should be, because but for them breaking into houses and burglarizing, they wouldn't have needed a getaway driver, and therefore Dante Harris wouldn't have had to hit the accelerator and run over Officer Caprio. So respectfully.
I got it. So you basically believe that even an accidental killing in the course of a felony should result in a felony murder.
This was not an accidental killing. This was.
But felony murder encompasses an accidental killing.
You would have to.
Does it not?
You would have to prove the intent to commit the felony and that there was causation between the felony and the death. I think that's more than accidental.
Not for the actual culprit or principal. Like, for instance, in the case of Mr. Wells, where he and his co-defendants admittedly were committing an armed robbery and getting away, where the officer actually was the shooter. I would think you would think that would be an accident, that the officer didn't intend to kill the victim. So in a case like that, it's your belief that not the officer in any way, shape, or form, but everybody associated with the underlying crime of the robbery should be held accountable for the felony murder. You believe that?
I do, because they have engaged in dangerous conduct that puts others at risk, and therefore they should be held for the consequences of all the things that happen from that dangerous conduct. And you make the adjustment on the sentence, not on the crime.
I understand. That's exactly why we have, this, that's the thinking behind the statute of felony murder. But I think that as we have evolved in our thinking and in civil society, there are other places and other countries that have said this is actually barbaric and absurd to hold people accountable for a crime they didn't commit, where it's not even in any way proportional to the underlying crime. Again, I reiterate, there's certainly, what's the lengthiest sentence a person can get for first-degree felony in Maryland is what?
For first-degree felony murder?
No, I said a first-degree felony, first-degree burglary.
Oh, first-degree burglary, you can get 20.
And if they commit multiple ones, they can get consecutive sentencing, correct?
That's correct, 20, 40, 60.
And then you believe that is not adequate that is not an adequate sentence for the crime of burglary if a death occurs in one of them.
I do not, because
got it.
they are responsible for the
I
death.
understand. I hear you. I just find it absurd. I'm shocked even by you.
Okay. Isn't that so?
All right, Senator James.
Thank you. For any or all of you, we've been talking a lot about this emerging neurological studies about people's emerging brains. I'm very fascinated by it, and I've read a fair amount about it. But I am curious as to whether any of you are aware of whether these new studies and what neurologists are finding have delved into whether or not this emerging science would say to the public, this new science says people cannot determine right from wrong. They cannot determine that an armed robbery is not dangerous. I mean, in the context of this bill,
right?
I'm wondering if there are scientists who are studying this that are supporting the concept that people can't be held criminally responsible.
Nothing that I've seen has said that. What they're saying is the brain is not fully developed. There are 10-year-olds who know right from wrong. As you age, you learn more about what's right from wrong, not only first in your own home, then with your friends in school, but then more importantly, by the time you're 18, we all say knowing right from wrong needs to be known on the streets. And that's what we have all said with regard to every crime in the state of Maryland, now except for felony murder. When you have chosen to commit an inherently dangerous act. And the scientists are not saying they don't know right from wrong. They're just saying their brain isn't as well developed as it should be. I mean, I guess under that theory, I don't know, maybe Senator Carter, we'll see next year, that we couldn't charge anybody with crimes as an adult till they're 25. That doesn't make any sense either. So since Maryland accepts felony murder as a concept, then it should start with the age at which we accept that people are adults and responsible for their crimes.
And I think there's plenty of protections if people have diminished capacity, if they are suffering from a severe mental illness that prevents them from determining right from wrong, if they're profoundly disabled, and I think the Supreme Court has even weighed in on IQ.
Oh, sure.
In that, so rather than making a broad brush on emerging neurological science, which has not specifically looked at what this bill is addressing, we do already have an appreciation and an accommodation in the law for people with diminished capacity, severe mental health, or very low IQs, which may scientifically relate to your ability to be held responsible.
Absolutely. So you could file incompetency to stand trial. You could file a not criminally responsible because I couldn't form the intent. You could file couldn't file diminished capacity, but you could proceed under diminished
Right.
capacity, that you didn't have, you could put a psychiatrist on the stand to say that he didn't have the mental capacity to understand that that they were going to commit a carjacking. So, I mean, there are all kinds of defenses here that we can still have to face and prove against.
And as far as I know, even if we were to begin to look at this, to me, the more the better way to proceed is it's very fact driven. I don't think any neurologist working in this area, even dealing with cognitive ability and emerging, would ever be able to say with any certainty that one individual at 23 cannot be held responsible and another could. In other words, you would need to look at each individual case, and you really would have to have scientific data as opposed to a blanket sort of misappropriation of this emerging science.
Absolutely. And that's why this law doesn't delve into the individual. It delves into the entire population and labels them as not capable of being able to form the intent.
Thank you.
Thank you. One of the witnesses earlier posed a hypothetical of someone or people driving up to a convenience store, somebody sitting in the car, another person going inside, committing some sort of crime, somebody dies, they get in the car and go away. And under the current law, that person sitting in the car that may not have had anything to do with it or could be charged.
I would have
Could you speak to that?
Yes, I would have to prove that they were a willing participant in inherently dangerous felony. So if they picked two people up who got in the back seat and they didn't know they had a gun and they weren't talking about robbing the store and they thought they were just sending them in for a 6-pack of beer and they were coming back with beer and pretzels and then they were going to somebody's house, unless I can disprove all that, then I don't think that person would be found guilty of felony murder. I do have to prove active participation in the underlying felony. And the underlying felony has to be inherently dangerous. And you all have decided what those are by putting them in that statute. And so I think under your scenario, I might be able to charge felony murder, but I don't think I'd be able to prove it.
And Mr. Katz, if you spoke to, you gave an example about not being able to distinguish who was the principal. So you had multiple people who were at an incident and could probably point fingers at one another.
I'm giving a situation. Yeah, let's suppose, for instance, you had that scenario. They never recovered the gun. Okay, so we don't have any DNA. We don't have any fingerprints. We know is that, for instance, let's assume that at some point prior to going in, they were unmasked. Somebody from the police department recognized them. There was outside video, but there was no interior video. Or there was video taken of the license tag, pretty good video that they were able to determine whose car it was. Okay, so out of that came a suspect who then was arrested, was interviewed, and pointed an accusing finger at the accomplice. The accomplice is then picked up. He's being interviewed, and he says the person who was the first person who was picked up, he was the one that actually fired the shot. How am I going to prove who was the one that fired the shot?
When you just do additional investigation.
You might be able to do investigation, but without any additional evidence, how am I going to be able to prove? I got two people, both of whom went in there. Okay. There was one shot that was fired. One person is dead. There's no gun, as I indicated, no fingerprints, no DNA. All we know is that we know who the two people were that went in there. And we know that someone died. We just don't know who it was that fired the kill shot. And that's the best that we're going to be able to do.
Under that scenario, would you charge someone with felony murder, or would you just charge them both in separate trials for murder?
Well, I mean, it may not be able to prove that the person that the plan was to kill. I think the example that I used, I used an example in another situation.
And only as I'm asking, I'm trying to understand. I guess with felony murder, you're almost saying that, all right, I know you didn't, you weren't the principal.
Right. I cannot prove that the intent when they went in there was to kill somebody. in the course of committing the armed robbery, somebody got nervous, somebody got scared for whatever reason, he or she, for that matter, fired the kill shot. Okay, so we do have two people who are clearly principals in the first degree as to the armed robbery. The problem is with regards to the murder, since it was not necessarily something we can prove was with premeditated malice aforethought, the best we're going to probably be able to do is felony murder.
Thank you.
All right, additional questions? Seeing none, thank you all very much. Thank you. All right, now we'll switch to our virtual panelists and we'll start with, is Phil Kroon in the room? Gonna bring them all in. So we'll start off with the virtual proponents of the bill. So Elise, you're up. We can see you.
Thank you. Good afternoon, committee. I am coming to you live from a parking lot in Talbot County, coming back from court. I am Elise Desiderio, a post-conviction attorney with the Office of the Public Defender, urging a favorable report. I'll briefly touch on points from my written testimony, which I do recommend that members review. It includes links, it includes further reading. The felony murder concept started way back in the late 1500s as a way to show implied malice, or in modern words, implied intent to kill. Felony murder statutorily as a predicate for first-degree murder was first codified in Maryland in 1809. Much has changed in society since 1809 and since the 1500s, and yet felony murder persists. Qualifying felonies are now listed in the criminal law article at 2201. But some jurisdictions increasingly recently have abolished or limited this guilt by association rule, and Maryland has the chance now to join them. From my research, Hawaii, Kentucky, and Michigan have removed the rule entirely or never had it. In Ohio, the doctrine technically persists, but as of 2004, many situations that would have been felony murder are now considered involuntary manslaughter instead. California has redefined felony murder for accomplices to make the standard much more stringent and sets out procedures for those convicted under the old rule to apply for resentencing under the new. Colorado lawmakers have made it easier to successfully raise an affirmative defense for felony murder charges, which is not something that we can do here. DC has eliminated accomplice liability felony murder for those who did not intend to kill. So that is regardless of age. And today, Maryland too has an opportunity to reduce the harm caused by the felony murder rule as it exists today. OPD urges a favorable report, and I welcome your questions.
So thank you very much. Ms. Sutter, you're up next. Welcome. Good to see you.
Good to see you as well. Good afternoon, members of the committee. My name is Erica Suter. I'm an assistant public defender and director of the UB Innocence Project Clinic. I'm also president of the Maryland Criminal Defense Attorneys Association. I'd like to address some of the opposition's testimony. According to Mr. Schellenberger, it would have been much more difficult to convict Dante Harris, the driver of the stolen Jeep that killed Officer Caprio, and it would have been impossible to convict Mr. Harris's 3 co-defendants. As other panelists have mentioned, prosecutors have plenty of tools in their toolbox to hold individuals accountable for their conduct. If you've ever heard a prosecutor argue in closing argument about the time necessary to satisfy the premeditation element for premeditated first-degree murder, they will tell you mere seconds to consider one's actions is sufficient. So taking felony murder off the table for youth in particular would not hobble prosecutors. Also, prosecutors would retain the ability to charge someone with conspiracy to commit murder or under a theory of aiding and abetting. More relevant to this conversation, though, are the 3 boys, ages 15, 16, and 17, who were in a house that they chose to break into, but they could not see what Mr. Harris was about to do. They did not plan it. They did not intend it. They did not expect it. There were kids who did not consider the horrific potential outcome of their actions. They should be held accountable for the crimes that they committed: burglary, auto theft, or theft. but instead they were charged with first-degree murder and they pled guilty. The reason why they received that 30-year sentence that Mr. Schellenberger mentioned was because it was a binding plea in exchange for their agreeing to a first-degree murder conviction. It was not the case that the court looked at their level of culpability necessarily and chose to impose a lesser sentence. This bill is about holding youth accountable for the crimes that they actually commit and not a legal fiction that fails to consider the mental development of children. Thank you.
Thank you very much, Ms. Suter. Mr. Karoum, you're up.
Mr. Chairman, Senators, I'm speaking today for Maryland Alliance for Justice Reform, not for the court system. But I'd like to take my 2 minutes to go beyond my written testimony and respond to a brief opposition that was filed by the court's legislative committee. That's a committee I'm familiar with, which reviews about 100 bills that you have filed in a day and takes only a minute or two for each. Their brief response to SB 850 is that they think it should be opposed because it sets Maryland statutes set adulthood at age 18, and this bill would treat some adults differently. In fact, if they had taken the time for legal analysis as an appeals court would, if this bill were ever challenged, they would recognize that there is a long tradition and a rational basis to treat certain adults differently in both the U.S. and Maryland Constitution and laws. In the U.S. Constitution, you cannot be elected to Congress until you're age 25. You, sitting on this committee, could not be elected state senators until you were age 25. Under our laws, juvenile delinquency courts keep individuals under our custody until age 21, foster care until age 25, health care under your parents' policies until age 25, and criminal laws also differ according to statutory rape if you're 18, 19, 20, and we may still consider your juvenile record until you're age 23. So there's a long tradition of recognizing that common sense brain development policy. It is not something new. Many states have emerging adult courts which treat emerging adults under age 25 differently, including Republican states such as Texas and Nebraska. For all these reasons, I urge you to not be deterred by that comment of the legislative committee and to give a favorable report to SB 850, which embodies good public policy. Thank you.
Excellent. Thank you very much, Mr. Karoum. We'll now move on to Ms. Mitchell. You're up. I think we have to, Ms. Mitchell, we have to unmute you if you could, please. Sorry. Can you unmute yourself? There you
Okay.
go. We can hear you.
Thank you so much. My name is Ayula Mitchell. I'm currently in California where the weather is crazy. So if you lose me, it's the winds that are ridiculous out here. I've spent 40 years working in America's criminal punishment system. In my experience, the following three things have been constants since I first took a group of youth to San Quentin State Prison in 1984. Those three things are: one, Black and brown people continue to be incarcerated at disproportionately higher rates. Two, mandatory and extreme sentences do not prevent crime. And three, under the felony murder rule, the person who actually took a life could serve less time than their co-defendants. I have personally witnessed it, and it's not an anomaly. I've heard countless stories on both sides of harm. My most important story, however, is my own. On January 30th, 2009, my oldest son survived 17 gunshot wounds. 15 months later, on Mother's Day, my middle son was murdered. My heart was broken, my family devastated. The absolutely unimaginable happened again a few years later when my godson was killed by a drunk driver. None of America's or Maryland's extreme sentencing, including the felony murder rule, was going to help my family heal or make us safer. Never once did I desire another young person to be sentenced to life. From the onset, I knew my family needed resources, support, and love. I had to create this for me and my surviving children on my own. No one from the system that claims to represent the people ever asked me what I needed. I am interested in laws that help victims of violence, not ones that throw people away in our name. Thank you.
And thank you very much, Ms. Mitchell. Thanks for sharing your story. Next, we'll hear from Ms. Taylor.
Okay, hello, I'm here. Can you hear me?
We can. Welcome.
All right, welcome. Hi. Hi, my name is Shalita Taylor. I'm submitting this testimony on behalf of my loved one, Dominic Givens, and other parties that are affected by this particular bill. The nature of this charge that you all call felony murder is really disrupting to the justice system, let alone any individual who's under 25. I was once 25 and there were things that I wasn't fully aware of at this age. I did not understand the consequences behind noticing something was wrong until it was revealed, such as boyfriends and other manipulative situations. I say this because felony murder gives a young person life, even if they're not the actual killer. No time for repentance. I say this because felony murder is identically treated as premeditated and has the same sentencing guidelines as first-degree murder, which is unfair. In first-degree murder, it holds premeditation from the actual shooter, which causes the suspect, who was also charged with felony murder, who could be unaware, to be punished identical to the same mental state of the person that is guilty of first-degree murder. Now, the actions of this same young person who was given a life sentence identical to first degree is premeditating something, right? Which felony murder can stem from influence by the conflictions of this world, or just another young person being in a bad place and not being aware. Totally unfair. No one should be punished or labeled as a killer if they're not a killer. And anyone under 25 having their whole life taken away for unawareness, incognizant, bad influence, or just clearly being in the wrong place at the wrong time of another individual mind is totally unfair. Let alone get the same sentence as one is aware, unsensible, completely wrong, and flat out killer. I support this bill. Thank you for your time.
Thank you, Ms. Taylor. Next, we'll hear from Mr. Stenar.
Thank you, Mr. Chairman and members of the committee, for the privilege to speak before you today. My name is Braden Steiner, and I'm a third-year law student at the University of Baltimore and research fellow with the Center for Criminal Justice Reform. I'd like to use my time to share a letter from a directly impacted voice. Adnan Khan was the first person to be released from prison following a felony murder conviction pursuant to the recent passage in California of a similar bill to this one. Here's his message for the committee. My name is Adnan Khan. I'm testifying in favor of SB 850 as a person both charged and sentenced under the felony murder rule, as well as a recipient of relief under the felony murder rule change in California. On March 24th, 2003, I would commit the worst act of my life. A friend asked me to do a snatch and grab of marijuana from another young man named Kevin McNutt, whom I did not know. The agreement was there to be no weapons. I impulsively agreed. I was a teenager and I didn't understand how risky my behavior was. Since neither of us had a car, my friend called another young man to be the getaway driver, a man I didn't know. Once Kevin handed me the marijuana, what appeared to be a fight broke out between Kevin and the getaway driver. I got out of the car and yelled at him, "What are you doing? Get back in the car." The getaway driver then ran back to the car and we left the scene. I was arrested a few hours later at 2 a.m. and taken into interrogation. That's when the detective told me I was being charged with robbery and murder. I found out the getaway driver was bipolar schizophrenic and was not taking any of his 8+ medications assigned to him. He had a concealed knife on him, which he used to take the life of Kevin. I was 18, charged with felony murder. I faced the death penalty for my first 18 months of incarceration. And after 16 years of incarceration, the same judge who sentenced me to life in prison modified my sentence due to the change in California's felony murder law, and I was released. I'm proof that we don't need to throw young people away to make society safer. Thank you for the privilege to share Adnan's story. Now, speaking for myself as a law student, it's incredibly disheartening to hear experienced prosecutors defending a legal fiction absent from the legal system of all other first world countries. Thank you.
All right, thank you very much. Ann, you're up.
Thank you. My name is Ann Bokini Kirsch, and I'm Director of Advocacy for Prepare. We do parole support and reentry support. So I end up seeing these cases when they are 15, 20 plus years old, which means I get the perspective on the person, not when they are the juvenile or the adolescent, but when they are the 30, 40, or 50-year-old man who is going up for parole and making a presentation. And to me, this is about accuracy. A conviction of first-degree murder with a life sentence comes with all kinds of additional collateral consequences, consequences that should not be applied to somebody who simply was sitting in a car as a getaway driver, somebody who's young, and as has been said many times before by other people, who had no knowledge or planning of a loss of life or murder. I've seen many cases where the first degree principal, the person who actually pulled the trigger or committed the murder, is going up for parole, is being released, or has already been released. And somebody that I'm working with who was an emerging adult, who has been in prison for decades, is still waiting and still going through the extremely difficult parole process that is assigned to life sentences. So I'm asking for a favorable report, knowing that while this bill will not help the people that I'm currently working with, it will stop people from being added to my queue. And it will give these young people who, yes, do deserve to be in prison for their participation, but do not deserve to be in prison for a life sentence based on the lesser amount of their participation. It will give them an opportunity to do well and obtain release through the parole system. Thank you.
Excellent. Thank you very much. All right, that'll conclude the testimony for the proponents of the bill. We'll now switch to the virtual participant in opposition. Mr. McAvoy, you're up.
Thank you so much, Chair and Committee. I appreciate your time on this bill. I am unfavorable on SB 850 and its HB 1180 brought by Joe Carter and by Senator Joe Carter and by Delegates Crutchfield, Bartlett, and Davis. And I just want to give kudos to the staggering mic drop for Senator Chris West on the so-called brain science. He hit that spot on. And I was just in HGO subcommittee this afternoon where it's being used in a twisted way, upside down, where children above the age of 14 are given the benefit of the doubt regarding self-mutilation. Folks, we can't have it both ways. And the disingenuousness of how this brain science issue is being used is just falsehood. This bill, both the bills are wrongful and wrong-minded given the demographic of those committing crimes in Maryland, the tone and tenor in the state of increasing murders, carjackings, additional rapes in Towson recently. This is not the bill that we need now. Further, we just spent an hour and a half on a bill for basically, the fiscal note says, maybe 41 inmates. This is a wrong-minded approach to criminal justice. Child murders are killing other children. I hear that people are saying that they will be charged and other cases will be brought. That's just not so. And I point to when I did the incarceration report for child support, long list of crimes not being charged. And I point to the homicide and rape clearance rates in Maryland. That does not aim toward this bill. And also I add that there could be, I don't know, but there could be some possibility by the use of detectives when they're figuring out who is the murderer or who has perpetrated these type of capital offenses, these type of criminal offenses, when evaluating who is guilty. So I urge an unfavorable for this and to listen to Chris West on the brain science issue. Thank you.
All right, thank you very much. Seeing no questions for the participant, that'll end the testimony and the hearing for Senate Bill 850. We'll now move on to Senator Folden with Senate Bill 752.
My panel settled in, Mr. Chair. 7-5-2. Save the best for last. Save the best for last. Okay. Am I good to go? I agree. Do I hear a second? Thank you, Mr. Chairman. Members of the committee that are left. Senator Fulton, Frederick County, District 4. What I have before you today is SB 752 in regards to police discipline, the order to show cause. And this bill is pretty simply put that authorizes the police officers to deny a right granted by laws relating to police accountability and discipline to apply at any time before a hearing is held by the hearing board to the circuit court that directs the law enforcement agency to show cause why that should not be granted. So it's a pretty simple and clean measure. And with that, I would ask for your favorable report, and I'll turn it over to my panel.
Good afternoon, Mr. Chair. Michael Davey, the General Counsel to the Maryland State Fraternal Order of Police, and we're requesting a favorable report on Senate Bill 752. As the Senator just stated, the passage of this bill will allow a law enforcement officer who believes that one of the sections or rights under the Maryland Police Accountability Act were violated. It would give that officer the ability to file what's called a complaint of show cause in the circuit court of Maryland and have a judge make the determination as to one, whether that right was violated or not, and if it was, what the equitable remedy would be. We're trying to get out in front of some of these cases that don't go to a trial board. Basically, what would happen is a show cause will be filed, and it must be filed before the beginning of a trial board. It would go to the circuit court that has jurisdiction, and the jurisdiction we used in this bill is consistent with 3-113 of the Police Accountability Act, which is the appeal process. Local jurisdictions go to the circuit court in the county in which they are. State and by-county agencies would go to the circuit court in Anne Arundel County. Basically, we're trying to do this for judicial economy. We're trying to get out in front of some of these cases that, depending on what the remedy, or if the judge determines that the right or the section was violated, what that remedy would be. It may prevent a trial board from even having to occur. Just filing the complaint does not stay the administrative trial board. It's not an automatic. You can request a stay. The court doesn't have to grant it. There is case law on previous administrative hearings where the courts have basically ruled that if the department goes forward with a show cause pending, they go forward at their own peril, knowing that if the right was in fact violated, they may have to do the trial board again. For those reasons, we believe this is a good bill for judicial economy, getting out in front of problem issues, and we request a favorable report. Thank you.
Good afternoon, Mr. Chair, members of the committee. Again, for the record, my name is Clyde Boatwright, President of Maryland State Fraternal Order of Police, representing 21,000 police officers throughout the state of Maryland. Just give you an example of why we feel like the show cause order would be important. We had a case where we had a number of police officers that were under investigation for an alleged felony offense. Those officers were suspended without pay for a period of 6 months. And during that time, their bills continued to come in. Once the state's attorney reviewed the case folder, determined that criminal charges were not warranted, those officers were returned immediately back to pay status. So there was 6 months without pay. The healthcare was in jeopardy, school's tuition and everything was in jeopardy during that time. So had we still had a show cause order, which we had prior to 2 years ago when we made the changes to the Maryland Police Accountability Act. In the old LEOBR, a show cause order would have been filed under the new rules of the Maryland Police Accountability Act to show that the offense, alleged offense, occurred during the LEOBR days. However, but the suspension of police powers and the suspension without pay occurred after the Accountability Act had taken place. So we feel as though that this is a strong mechanism to right some of the wrongs that some police departments can interpret the law without having the correct view of what the law, the written law is actually saying. So we feel as though that this is an important step to correcting the wrong, as Mr. Davey said. And with that, we'll urge a favorable report.
Good afternoon. For the record, my name is Michael Shire. I've been a police officer for 19 years in the state of Maryland, speaking today on behalf of the Maryland Fraternal Order of Police, also an attorney here in the state. Thank you to committee chair and committee members who are still hanging around here to hear this testimony. Speaking for the Maryland FOP in support of Senate Bill 752. I think the best way to kind of understand this bill is to look at it as a dispute resolution mechanism. It allows officers and investigating agencies to fix procedural problems quickly and efficiently instead of waiting till the very end of a disciplinary process to realize an error was made and to then have to start all over again. This allows that mistake to be corrected right away so the process can proceed to a final resolution. I'm going to give you an analogy. It's like building a house where one of the workers points out that there's a problem with the foundation, but everybody ignores it. When the house is built, the building inspector comes in and says, yep, there's a problem with the foundation. Tear it down, start all over again. Wouldn't it have been just easier had the problem been noticed and fixed before we spent all the time building a house just to have to tear it down again? Show cause order allows the court to come in when there's a question as to whether or not something is wrong with the process that's being conducted and allow a fix to be implemented before you build the entire house of the entire disciplinary process upon a bad foundation. It's a quick and efficient way of settling that issue. This was the goal of the MPAA. It was to settle these things, to adjudicate disciplinary issues quickly and efficiently and get to a final resolution. This bill actually helps achieve that goal. Therefore, the Maryland State FOP asks that you report favorably on Senate Bill 752. Thank you.
I have a question for the gentleman that just, the previous gentleman that just spoke. I apologize. Can you remind me of your name again?
Clyde Boatwright.
Good to see you, sir. Thank you.
Good to see you.
Thank you for your service as well.
Yes, sir.
The example you gave about the gentleman, the officer who was suspended for 6 months without pay and end up being exonerated. How many of those cases are prevalent? I mean, because there's I've seen a lot of suspensions that happen without pay that happen, and specifically in Prince George's County. And the ones I see that make the news, obviously, are the ones that when people are actually not exonerated or found criminal in those cases. Can you just give us this percentage of how many of those cases that are where they get exonerated?
Typically, when the case is investigated, so as the old saying goes, you can indict a ham sandwich. Once the indictment comes, the police officer is now suspended without pay. But once further investigation happens, in some of these cases, I don't have an exact percentage on how many are overturned. But if you're suspended without pay and the charges are dropped, you should be returned to pay status.
No,
and it does happen.
No, I totally agree with you on that. And but I think it'll be good for us to have because we did just change this law, right? And so it'd be good to know in this case afterwards, how many of these cases are going through that process or that we have or we need to actually make this change?
Well, the merits of the particular example I gave was the interpretation of the MPA, the Maryland Police Accountability Act. It was the chief's interpretation that now I can do this. I can now do this because the Accountability Act reads that way. When in fact that if we would have had this show cause available, the judge would have been able to say, no, that this happened pre-MPAA and happened under LEOBR. And so therefore you're out of bounds with your interpretation.
Got it. Thank you. And when last question, when those officers are suspended without pay, are they still represented in those cases by the state's attorney or the county's attorney in those cases, or an attorney from the public, or do they have to get their own from the FOP?
It depends.
How does it work?
It's the officer's discretion. Am I correct, Mike, on that?
There's three areas. The criminal end, obviously, they have to get their own attorney. From the civil end, if the officer was working within the scope of his employment at the time, then the county attorney would take it. If the determination made, kind of like the gun trace task force, that they were not working within the scope of their employment, they're on their own. They have to get their own attorney.
Got it. Thank you.
From an administrative point of view, even though they're suspended without pay, if they're a member of the Fraternal Order of Police, they get an attorney.
Got it. Thank you.
All right, additional questions from the committee? All right, seeing none, thank you very much. We're now, that'll end the testimony for the proponents of the bill. We'll now switch to the opposition panel. We have Janet Emanuel, and is Mr. Love still testifying on this? And then, yes, I have you, Mr. Spencer?
For information.
Yeah, for information only, yes. If you want to go ahead first and then we'll do the opponents. So you can come up now.
Your committee, sir.
Yeah, you got it. Information first and then we'll do the opponents.
Thank you, Mr. Chairman. Good evening. My name is Jerome Spencer. I'm the General Counsel of the Charles County Sheriff's Office. I'm here on behalf of the Maryland Chiefs and Sheriffs Association. Part of my day job involves handling discipline matters for our agency. To be very clear, we're not here opposing this bill or supporting the bill. We fully support our officers' right to have due process. We want to give you 4 points to consider when you consider this bill. First, a show cause order by definition is going to put in delay into a discipline proceeding. It's going to cause delay to go to circuit court, get your circuit court hearing. That could be a few days or a few months. I've gone through cases dealing with it under the LBR, and it could be a few days or literally months before you get that hearing before the circuit court. Then you have an appeal period with the Court of Special Appeal. The Appellate Court of Maryland, the Supreme Court of Maryland. Delays will occur. Number two, typically when there's administrative process, the remedy is to go through the administrative process, have your hearing, and then appeal the circuit court. That's the traditional way that people get to complain about a flaw in the process. If it's a non-discipline matter, if each agency should have their own internal grievance process deal with that. So a question you have to decide is an officer going to have the opportunity to have a second way to complain about hiccups that may be occurring in his or her process. Number three, we're still early in the regime. HB 670 gave us a lot of challenges. We're working through them. There are issues that have occurred and issues that will occur. But we can't really say yet there have been issues where a show cause would correct these issues. And finally, number four on this bill in particular, this bill directs the agency to show cause. A lot of the issues are going to occur that an officer is going to have concern about do not involve the agency. We are not the Administrative Charging Committee. We're not the PAB. We can't control an ACC taking 35 days to do the report when they have to do it in 30 days. So direct the agency to show cause or something the agency has no control of doesn't seem to make a lot of sense to us. So with that, we're happy to answer any further questions you might have about what the show cause process looks like and the impact it can have on internal discipline, internal issues.
Good afternoon, Chair Smith and members of the committee. For the record, my name is Yunetta Manuel, Public Policy Director with the ACLU of Maryland, here in opposition to SB 752, which seeks to authorize a police officer who's being investigated for misconduct to interrupt those investigative proceedings by filing a claim in the state circuit court that certain rights are being violated. In doing so, the proponents seek to bring back an unnecessary and harmful provision of the Law Enforcement Officers' Bill of Rights. In 2021, the Maryland General Assembly repealed Leobor and thus removed most of the special rights that police officers previously had in connection with the disciplinary process, including a waiting period before they had to cooperate with internal investigations and limits on who can conduct them. And of those that remain, such as the requirement that administrative charging committees approve disciplinary charges or a strict 1-year time limit in bringing charges, those are straightforward and easy to apply. And for those remaining procedural rights, as well as the substantive protections for whistleblowing, political activity, and secondary employment that could offer any defenses to discipline, officers should be treated as any member of the public and file those an appeal or dispute those before the trial board. Rather, an officer, what SB 752 seeks to do is allow an officer to raise these provisions before as a defense to any disciplinary charge if it's ultimately brought. If the defense is rejected, it can be raised, like I mentioned earlier, on appeal to the circuit court of any discipline imposed. If this bill is adopted, it could allow police officers to effectively prevent departments from being able to discipline them. An officer could file a ridiculous, frivolous claim, claiming that a right has been violated, and the resolution to that claim would interrupt the investigation, just as the individual before me mentioned, and could easily be granted and would run out the 1-year time limit for completing the investigation, making it impossible for an officer to be charged if the court ruled in no violation of the officer's rights had occurred. SB 752 thus is a way for guilty officers to escape discipline and accountability, and for those reasons, we urge an unfavorable report. Thank you.
All right, good afternoon. Davon Love, Director of Public Policy, Leaders of a Beautiful Struggle. I want to start by addressing what I think is the underlying premise of this bill, the notion of the idea that the rights of law enforcement are under attack, which I think is a preposterous notion. When you think about the years prior to the uprising in Baltimore City and many of the major uprisings around the country, law enforcement, in terms of their reputation, were beyond reproach. Before the exposures of the Gun Trace Task Force, names like Wayne Jenkins and Daniel Herzl were infamous around the community, but many people didn't feel they could come forward and talk about
people being, guns being planted on them, police officers selling drugs, stealing drugs. These weren't things that people felt like they could report and be believed. Even in conversations that have happened in this committee, right? Senator Folden has referred to the idea of law enforcement, the reputation being besmirched or even dehumanized. But it's not police accountability efforts that have done that. It is the behaviors of law enforcement that are now extensively documented. And I mention it all the time, the Department of Justice Pattern and Practice Report, where you look at things like strip searches, illegal strip searches, people being brutalized. All these things were things that were happening. And now that they're exposed, it is now something that the community is responding to. And even looking at the report commissioned by the Senate, the Restoring Trust in Policing Act, commission that studied the attitudes about law enforcement, the majority of the folks that they interviewed had neutral or positive beliefs about law enforcement, but a majority of them said that they experienced or witnessed police misconduct themselves. And so I just want to make sure that we're clear that what we're talking about is the importance of holding an industry accountable that traditionally has not had mechanisms of accountability. In terms of the particular impact of this piece of legislation, what it does is that it creates even an additional layer of protection of rights of law enforcement, and additionally brings in the courts to be able to make decisions about particularly disciplinary matters, allowing the courts to act as an additional policymaking body as it relates to how these matters are adjudicated. And so with that, I urge an unfavorable report. Thank you.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you both. Thank you very much. That'll end the testimony and the hearing for Senate Bill 552. We'll now move on to Senate Bill 554, Senator Folden.
You mean 754? Yes.
Senate, for the record, Senate Bill 754.
Okay. Mr. Chairman, esteemed colleagues, for the record, Senator William Folden, District 4, Frederick County. Bringing before you today, Senate Bill 754, the Maryland Wiretap and Electronic Surveillance Reform Work Group legislation. This bill would just establish the Maryland Wiretap and Electronic Surveillance Reform Work Group. The work group would be tasked with studying specified issues regarding Maryland's wiretapping and electronic surveillance laws. And we just had a bill the other day brought forward in regards to young people who might be in the presence of the commission of a crime, whether another child was being abused or victimized, and if they were to turn on their cell phone and record those acts, that by the current law, because Maryland's a two-party consent, would be a felony in this state. We need to do better. We need to put measures in place that allow us to protect our victims and allow them to protect themselves through documenting these egregious acts that are preyed upon them by perpetrators. So with that, I'll turn it over to my panel and I would ask for your favorable report on Senate Bill 754. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Yosefi Seltzer. I'm an attorney at the JAG office at Fort Meade, and I'm here in support of Senate Bill 754. This bill will benefit victims of domestic violence, among others. The Maryland Wiretap Act, which was first codified in 1957, has been outpaced by technological advances and public safety concerns. The drafters could not have envisioned the use of mobile and satellite telephones, ring doorbells, and recording devices that empower individuals to protect their personal safety, particularly in domestic violence situations. This creates uncertainty and confusion when law enforcement and citizens attempt to comply with the arcane statutory language. Maryland courts have had their hands tied. This has resulted in unjust rulings such as in Seal v. Maryland, where a conviction of a child sex offender was reversed due to the fact that the defendant's incriminating recorded statements were deemed inadmissible because they resulted from the rape victim not having acted under the supervision of a detective. And Wood v. Maryland, where a defendant was barred from introducing a recording intended to impeach a government witness. The act also creates a conflict between Maryland's all-party consent requirement and the federal and military one-party consent standard. Federal witnesses run the risk of being prosecuted by Maryland. Due to the fact that reform attempts have been unsuccessful, it finally makes sense to gather experts on the subject and direct them to study best practices from other states, as well as federal process and procedure. Beneficiaries of the work group's efforts may include victims of elder and child abuse, human trafficking, abuse of disabled individuals, as well as exploitation of foreign-born Marylanders whose first language is not English. The work group has been carefully constructed to ensure broad representation from a wide variety of government and private sector stakeholders, and everyone agrees that it needs to be modernized despite the different legal philosophies. SB 754 will ensure the best evidence is available for judges to consider while balancing communication technological advances, privacy, and justice considerations. Thank you.
Good afternoon, Chairman, committee members. Charlie Smith. I'm the elected state's attorney in Frederick County. I'm the incoming president of the National District Attorneys Association, and I'm here to urge support for this bill. So anyway, a Republican, a Democrat, and an independent walk into a bar. All right. So, and no, not really. But if they did and they talked about this bill, they'd all come out in support of it. Right. So, and if they were all prosecutors, they'd all be talking about the inconsistencies that take place in each other's counties and the need for, hey, some work group to tell us how to do it in Frederick County, like they do in Baltimore City, like they do, down on the Eastern Shore. So there is inconsistencies. There's need for us to have a work group to tell us how to do it. And we tell police officers different things oftentimes within our counties. So there's need for police and prosecutors to have standardized practices. And this is the type of work group that's going to get that done. So we'd also probably talk about the horrors of these cases we see with child abuse and sex offense victims and domestic violence victims, and how inadmissibility poses a problem due to the current statute. And again, we're not a two-party consent state, we're an all-party consent state. It's a big difference. And with the advent of Zoom meetings, Google Meet, Teams, there's lots of wiretap violations that are going on. As a matter of fact, I saw on the door out front, one of your attorneys probably said, hey, you might want to slap a notice out on that door so everybody in here doesn't violate the wiretap statute, right? Because I'm getting recorded right now. Did I give is there active consent? Is there passive consent? There are all these issues that are going on now, especially with the advent of online meetings and whatnot. So again, we would urge you all to show favor for this reform work group. We believe it's needed to address all sorts of stuff in terms of the right to request erasure. Do you get personally identifying information encrypted when you're on these online meetings and whatnot? And again, this is really a nonpartisan bill that's just a good thing. And once again, we would urge favor from this committee. Thank you, Mr. Chairman.
Excellent. 3 conspiracy theorists walk into the bar at the same time. Now you can't tell me that's a coincidence. That's a bad dad joke of the day. All right, here you go. Welcome.
Thank you. I'm afraid I don't have any jokes, but good evening. My name is Jessica Garth. I am the chief of the Special Victims and Family Violence Unit at the State's Attorney's Office for Prince George's County. I also today represent the Maryland State's Attorneys Association. We are in favor of this work group and we do urge a favorable report. I came before this committee a week ago and I spoke about a case in which a woman had the foresight to know that she was going to be a victim of a violent crime, and she recorded her own rape. Unfortunately, she used her cell phone and was not able to capture any video, but was able to capture the audio of her own rape, which is inadmissible at trial. And when you lose evidence like that as a prosecutor, it reduces your cases to what we call he said, she said cases. I know we're all familiar with the term, and I know all of our juries are familiar with the term when they come back with not guilties on these violent crimes. Another active case that we have right now is where a woman recorded speaking with the defendant after he had raped her. They were inside her vehicle. On this recording, you can hear her more than 20 times beg him to leave her vehicle, and he refuses while he's trying to convince her that it wasn't rape, that in fact they had had sex. Again, this evidence is inadmissible. I know this work group may not bring an immediate change to this problem, but it is something that we can face from all sectors across the board. All political leanings are in favor of this work group. I would urge a favorable report on this for the modernization of the statute so that we can proceed with prosecutions with the best evidence available. Thank you.
Senator Washington.
Thank you. maybe this is for Senator Folden, but I wonder if there's been another work group in another state that looked at some of these and made recommendations, or maybe there's a study that shows what the best practices are that we can look at that might be out there already. I do appreciate this work group coming together specifically because of the bill you had that was here last week, but it'd be good to have something that's out there already that we can look at.
You got it. Go ahead and stand.
Hi, Senator. So we didn't look at that. Frankly, this is a legislative problem in the state of Maryland. As you can review in my written testimony, it's not a Fourth Amendment issue. Maryland's law is unique. Maryland is special. So Maryland needs to get together, bring the best minds together, which is what this work group is designed to do, from all legal philosophies, the defender's office, the prosecutors, legislators, nonprofit community, et cetera, and sit down and study, put their heads together, academics, evidence experts, privacy experts, and solve this and do what we can for the best of Maryland to modernize law.
Got it. And I haven't seen the full bill, but it has all the list of all those folks that you just indicated, right? You can say yes.
It does, Senator. And there's been some friendly amendments from some of the folks that have submitted testimony and supported it. And we believe those are all friendly additions to the panel.
Got it. Thanks.
So Maryland is about one of 10 states that's a two-party, all-party, I'll call it consent state. So we are somewhat in the minority. There are about 3 or 4 states that actually have a blended one-party, two-party. So I think that was a result, maybe not of a work group, but of a study of the legislation. It says we don't just, let's not paint this issue with a broad brush. Let's take a look at certain circumstances where one-party consent is actually a really good idea. And so they have a blended one-party, all-party type of statute. So I would imagine that was probably the result of taking a look at incidents such as the ones we talked about. So
the answer I was looking for.
Yeah,
Thank you.
great.
Appreciate it.
I just wanted to add one brief comment. Purpose of this work group is not to make Maryland a one-party consent state. That is not the intent here. The experts in this work group represent various perspectives on what is the best outcome. And we want to get them together to have those conversations and then present recommendations to this committee. The committee will have every opportunity to decide what they like and what they don't.
Thank you.
So I just want to chime in also. We were just talking back here with Ms. Jordan, and she brought up a really valid point, which was we're not trying to eliminate that, but it would be an affirmative defense for a good what we say, affirmative defense for a good faith relief. Right? Isn't that what we said? What you said? So that language is what's important. We're not trying to abscond anyone of any type of reckless liability. But what we do want to do is have safeguards in place for victims to not feel like they're going to be prosecuted for doing something that they're trying to protect themselves or others.
Right.
So
No,
thank you.
Thank you. As I look at the makeup of the work group, I mean, I know you all said it was balanced, but I'm counting 4 prosecutors on here and 2 defense attorneys and the court, possibly 2 members of the court, possibly 3 members of the General Assembly, 2 privacy people, and then a couple attorneys in a variety of areas. If I were making this, I'd probably eliminate a couple of the prosecutors just to make certain that there's a balance. As you may know, earlier this session, I had a bill in dealing with the wiretap law as well, but focused on its use in fair housing or civil rights cases. I would certainly include that on the study so that's not just focused.
Yeah, and I think that's something we could collaborate on. I think the important part is that we're just looking at a diversity of thought from all the stakeholders that we get the best product that's going to be beneficial to everyone.
Gotcha. But Chris, he turned to me and said, "This is something you could support." And I'm like, "Yeah, I could." I mean, I think we're on the same page.
Yeah, we are,
kinda.
and I think it's very, very much achievable. And I think, like I said, working together, that partnership and showing that it's not a partisan issue, but a safety issue and a rights issue is the standard we should all gauge from.
And the idea of a blended system, because I'm certainly I'm not a proponent of getting rid of where we are in Maryland as well.
Sure.
But there's some circumstances where you could see having.
Yeah, and I think that's what Lisa and I were just talking about. I mean, she brought up some really great points And I'm sure she'll echo those sentiments, but it's important to have that, that your intentions are in the proper vein for us to all succeed in achieving this together.
Thank you.
Yep.
All right, seeing no additional questions from the committee. Oh, nope, no questions from the committee. Thank you all very much. We'll hear from the next, I think it's just Ms. Jordan. And we have Ms. Shapiro who's joining us virtually.
Oh, wonderful. Good evening, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of Senate Bill 754 with amendments. And, the amendments are really, I think several of us would just like to be involved in the committee. So we're asking to be involved. I would note particularly, though, with the Maryland Coalition Against Sexual Assault, that it seems like a lot of the examples that are being used as justification for admission of this evidence relate to sexual assault, to child sex offenses. And so I do think it's very important, and I'm frankly troubled that we have to actually have a work group for something that perhaps could be worked out more quickly. Although I have to say to Senator Sidner, I had not thought about the implications in civil rights matters, and perhaps that's something that could be done together. I appreciate Senator Carter made some very valid points, and I think there are some real concerns. We don't want to put people at criminal jeopardy. At the same time, we also have a bill, at least in the House, that would reduce the penalties down to misdemeanors. And even if the belief is not reasonable, I think if somebody has a good faith belief that they're about to be a victim of a crime or perhaps a civil rights violation, that personal good faith belief ought to be an affirmative defense. And we really could solve it that way. MCASA is not advocating moving to a two-part or moving away from the two-party consent standard. So I'm happy to answer questions. I do hope you include us on the task force if you decide to enact this.
Excellent. Thank you very much. It's no longer two-party. It's all party consent.
All party.
Yes,
I'm
yeah,
sorry.
that's the new
I stand
vernacular.
corrected.
Yes. No, I'm kidding. All right. Seeing no questions from the committee. Thank you very much.
Mr. Chairman,
Senator,
I just wanted to also point out, I'm sorry, that this is supported by the Attorney General, and he is actually wishing to be a part of and actually chair this. So I think that that's a really good move in the proper direction for everyone, having his support. So thank you.
Excellent. All right, Ms. Shapiro, you're next. Welcome.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. I am Melanie Shapiro, the Public Policy Director with the Maryland Network Against Domestic Violence, here in support with what I hope are friendly amendments on Senate Bill 754. I'd like to thank Senator Folden for bringing this bill. We've dealt with different versions of legislation surrounding the wiretap statute for the last several years, as long as I can recall. And there's been no resolution, and different versions of the bills keep coming back. And in our testimony each year, the last 3 years, I've asked that a work group be created, because I think that this is the most effective way to bring all the parties together to address the concerns and the issues and ensure that we move forward in a way that does not have any unintended consequences and uses the proper language and ensures that everybody can weigh in and have a conversation. The network too has no position and is not trying to go and get rid of the all-party consent. But if there are going to be exceptions, that they be well thought out and don't have any unintended consequences. And we think that the work group is the best way to facilitate that. We would like the Maryland Network Against Domestic Violence to be included, as well as the Maryland State Bar Association Family and Juvenile Law Section Council, MCASA as well. And so therefore we urge a favorable report with amendments. Thank you.
Excellent. Thank you very much, Mr. Shapiro. Questions from the committee? All right, seeing none, that'll end the testimony and the hearing for Senate Bill 7.